Learned counsel for the petitioner raised that the matter will be taken up after the litigation. Prayer is allowed. List this matter. You are there in item number 59. One person. Actually, this is mentioned going. 59. So prayer is allowed. List this matter when? After litigation, any date. List this matter on 3083. 30th of April.
Obliged, madam. Lordship, I'd like to mention for upgradation of item number 56. It is in hearing stage, Lordship. Lordship, the case has been listed many times, but we cannot, the case has not been reached, Lordship, due to lack of time.
Okay, we will
So, maybe upgraded.
We will see after finishing the motion admissions. Okay.
Time may be fixed.
Anyway, it cannot be before 2 o'clock. So at 2 o'clock.
It is fixed. 2 o'clock.
Not fixed. How can I say? Let me see after finishing the other matters.
Okay.
Okay. I'll give preference to that once the hearing starts.
Obliged. Obliged.
Hello, it is regarding provincialization of service of the petitioners, my lord. So, my lord, it may not be sent to the mediation, my lord.
Why try it once?
My lord, whether they are eligible or not, that has to be decided, my lord.
Whether they are?
Eligible for the provincialization or not, my lord. This
That
is,
can also be seen by the mediator.
then, my lord, it can.
What do you say? Not sure. It can be let it go for mediation. Then if it doesn't come out successful. See. Mr.
K would be, my lord.
K. did learned counsel for the petitioner. Heard Mr. K. And Miss R. Borua, learned counsel for all the respondents. Learned counsel for all the respondents. As agreed to by the parties. Please send this matter for mediation. As agreed to by the parties, the instant case is sent for mediation. As such, the case is referred to the Gauhati High Court Mediation Center, who would appoint a mediator, who again would call the parties, hear the matter, and prepare a report, and submit the same before this court. Full stop. The mediator is directed to prepare the report, with preferably within a period of 2 months. List this matter there.
Obliged.
Similar issue, my lord, but right of the parties is required to be, my lord, adjudicated by the court. It is provincialization, my lord, and some other petition is pending and some other petition has been disposed of also. That is the problem, my lord.
So this is a similar case, let it go to mediation, he has also agreed.
That is correct, but my lord, it may not be, my lord, adjudicated by the mediator. To my, no, that is why it may be fixed for orders. In the meantime, my lord, some others matters may come. All the disposal of matter also are there.
Those can also be sent for mediation if there are so many matters can be disposed of.
A list I have, so it is not listed. Can it be, my lord, along with the?
No,
Yes,
what
ma'am.
I'm saying is those matters can also be sent for mediation.
That is,
along-
but that those matters,
Let it be tried once, since,
but date may be, my
okay,
lord,
it may not be 2 months or 1 month.
1 month, my lord, that is
Earlier also you make it 1 month,
1 month.
preferably 1 month, huh? Okay. And we have heard Mr. N. Hawk, learned counsel for the petitioners, and R. Borua, secondary education, says standing counsel secondary education, as agreed to by the parties. The instant matter is sent for mediation. Accordingly, the case is sent to the Gauhati High Court Mediation Center, who would appoint a mediator, and the said mediator would call the parties, hear the matter, and prepare the report and submit the same before this court, preferably within a period of 1 month. Listed thereafter.
Okay.
Nobody from the petitioner side. Can it be sent for mediation?
No, my lord, they have silence, passing and setting aside of a notification issued by the Gauhati University.
The setting and quashing of what?
Notification.
Notification.
My lord.
So it can go for mediation, let it go.
Mediator cannot pass the notification, my lord.
No, they will give an opinion. Thereafter, this court will quash.
The petitioner is also absent, my lord.
The data was there in 22. After that matter did not come up.
My lord. And probably the matter has become infectious.
The council said the petition side is also not there. Let it be decided by the mediator then. Or let the petitioner's counsel come, but then I don't think so he has any interest now.
My lord.
22, after that, the case did not come up. And who is this D Deca? Do you know? D Deca?
I have no idea, my lord. The matter be listed after 2 weeks. Recording his absence, my lord, today.
None appears on call for the petitioner. Well, Mr. You are for? Mia, no.
I agree with you.
Mr. Mia for higher education and
If this Sharma for respondent number 4 and 5.
for respond number 4 and 5, and you?
I shape on behalf of PK for Constitutional Council Gauhati.
And learned counsel is appearing on behalf of Mr. P.J. Pukan, appearing for Gauhati University. List this matter after 2 weeks on a date to be fixed by the registrar.
I agree. Yes.
Mr. Mia, mediation?
Milord, actually our prayer, Milord, reflects that the virus had been challenged. Whether the mediator can take up the challenge of a virus of a particular provision of an act is an issue. If your lordship desire, Milord,
Virus is challenged, then it should go to the division bench.
Milord, what has happened initially, this was before the division bench.
Hmm.
That matter, Milord, regarding the challenge to the Provincialization Act of 2017. So during the, this was also tagged along with the series. Now, during the course of the hearing, Milord, the Honorable Division Bench has segregated this matter and directed to be listed before the single judge, Milord. That is reflected in the order sheet also. So
But
now,
if virus is put to challenge, then
My
what?
now, Milord, the virus of
Or there
that.
is some new notification?
No new notification, Milord. The Honorable Division Bench has held that, Milord, the issue which we have raised is not required to be adjudicated. Otherwise, the single judge can also, if we can make out a case, then, Milord, our relief can be granted, Milord. That was the view expressed at that relevant period of time, Milord. That's why it had been segregated. Now, Milord, as this.
Now, without going into the virus of the act,
Yes, Milord.
then let the mediator hear.
My lord.
If the virus will need not be gone into.
My lord.
Okay, as agreed to by the parties. That is learned counsel for the petitioner. As well as learned counsel for the respondents. The matter is sent for mediation. According the Gauhati High Court Mediation Center would appoint a mediator, a same thing, who would who would appoint a mediator and then so and so. Yes, sir. Preferably within a month.
Obliged.
Same things.
Deeply obliged.
5 and 6.
Yeah, please, your lordship.
5 and 6
Yes.
together.
Together also. This matter pertains to departmental proceeding and suspension.
Departmental proceeding and suspension.
Yes.
Mediator can give an opinion.
Lordship, please, sir.
Same, as agreed to by the parties.
Then in time limit, one.
One month.
Okay. That's true, but you that is on election, that's fine. If
So make this too much. Preferably, I'm saying,
This is not a.
can also increase. This is preferably within 2 months.
Obliged.
What's a party's name? Mr. S. Sharma, right? No,
SK data.
SK Deca, Learned Counsel for Petitioner, Mr. Mia for respond number. Or
Higher
for
division, one.
higher education,
No, sorry.
for higher education and Mr. For respondent,
Item number 6.
respondent number 4 in item number 65. Oh, 5 of them.
Clear.
Mr. Mia again, yes.
My lord, similar matter, my lord.
Provincialization.
Provincialization and that issue, my lord, regarding the virus, my lord. Can be,
So virus need not be gone into and then
can be sent before the mediator, my lord.
mediate. Same order. Mr. A.R. Mia and R. Guru.
Obliged.
Mediation? Agreement? Oh, counsel is not there.
Petitioner claiming is first wife, my lord, but I am the first wife, my lord. And
Pension?
yes, my lord. Compassionate family pension, my lord.
You are the first wife.
Yes, my lord.
And the petitioner is the second one.
Second wife, my lord. But she is claiming, my lord, that she is first wife, my lord. Here is my lord. But
Okay, let the mediator hear and give an opinion. Okay?
yes,
Okay.
within 1 month, my lord.
Within 1 month, people. For 1 to 6. Learned counsels for the respondents, I'll say. Respondents. The series matter stay vacated.
Stay vacancy lordship modification may be other lordship, it is or for regular appointment of regular headmaster. Lordship, I have also filed stay vacation petition and another government also filed similar.
On last of
On last occasion, your lordship was supposed to hear the entire matter. So that was what has been suggested by the learned advocate general. But today probably they have.
What needs to be done? Yes, Miss Mia, you are also there.
Only-
To prove their BTC.
So against the
Would
state
you-
of Assam.
only difficulty is, my lord, there are some other matters listed before the court over 15, my lord, which is connected to this series, my lord.
Everything should be heard.
Yes.
Exactly, my lord. So, madam, we'll fix it on 7th of May, my lord.
5th of May, your lordship.
And what about those matters in the other court?
We'll mention there, my lord.
So get it tag, all the matters
Yes,
together,
yes.
then, right?
Yes, ma'am.
Okay, and heard Mr. S. Bhattacharya, learned counsel for the, there are so many petitions,
Yes,
right?
I mean.
So I will not pass.
No, sir.
Similar other heard learned counsels for the petitioners and the learned counsels for the respondents as well. It is stated at the bar that similar petitions are also pending disposal and are being listed before another court. And the further prayer is made that all the matters may be taken up together. As such, the present matters may be listed together with, there are so many matters.
No, no, only one matter is the clue.
Or they give the number with writ petition number so and so of 2000.
4031/2024, madam.
4031/2024. It is also jointly prayed that the matter may be taken up on 7th of May,
Lordship, I am praying for 5th.
5th of May.
5th of May for final disposal. List it accordingly.
Obligation.
Item number 9 and
37.
here will also all be listed together.
Interim may be extended.
Oh, interim, there are only in your matters.
I know about my.
Only
Item number
in item number 9, there is an interim order, madam. In other matters also,
following each and every
37.
matter. Item number 9, you write interim order passed earlier shall continue until the next returnable date. And which is the other one?
And 37 lordship.
37 of interim to continue. Okay,
Till then, madam.
step as well.
till then, until then.
Obligation.
Okay.
Yeah, please, lordship. Lordship, kindly pass over the matter for time being. My senior is currently engaged in another.
Acha, this is admission matter. Earlier mediation was rejected, right?
Yes, ma'am. Yes, Lordship.
Okay, after some time.
Yes, Lordship.
What are the counsels of the for the petitioners? Okay. After some time.
You see here, this is this.
You need to say something. After some time.
Yes. Obliged, Lordship.
Forty-two and 43, councils are not there. What about government? They are there.
Main party is social justice.
Lead council is not there.
What happens? They'll come after some time or no?
After some time.
After some time. After some time, huh? 44. Yes, 44. What happened with the councils?
Your ladyship, I'm appearing on behalf of Mr. Pinayak for JFC. He's on legs, your ladyship. Can the matter be taken up after some time?
Even last occasion, none appeared for the petitioner. What happened? Matter has become infructuous or what?
We have to ask the petitioner.
Okay, let your Mr. Nayak come.
Yes, your ladyship. Obliged.
And appears and call for the petitioner. List this matter again on. Again on. 9th of April.
We have filed our affidavit.
Already okay.
Obliged.
No. Yeah, for which?
Lordship, in the series, TED series, I extended the interim only for 9 and 37, but the interim was also for 38, 39, and 40.
38, 39, 40.
40.
38, 39, 40.
Much of this.
I'm not checking, I'm relying on what you're saying, okay? 38, 39. Uh-huh. 37 to 40. 6 to 48 is
I think 48 may be taken.
48 may be taken. 48. The parties have filed their affidavits.
Two affidavits I have received and I filed the reply also.
It seems they have filed. Mr. R.R. Kaushik took time on the last occasion to file affidavits on behalf of NC Hills. Whether that is done?
Passport number 8 has filed. And passport number 7.
R7, right? 5? What about 5?
They have not responded.
It's okay, I think that will do. Right?
7 and 8.
Or you need affidavit by 5 as well.
No, they are filed.
That's okay.
Yes.
So who is appearing for the government side? Ms. Mushari, you are there. Because what happens is that I hear a matter for considerable time, then the government side comes and says, no, they have to file it. So let's see what is, if the pleadings are complete, I can hear, otherwise I'll not.
NC Hills
Yes, I'm R.R. Kaushik. So, respondent number 1, you are there.
1 and 2.
1 and 2, you are there. NC Hills, 3, 4. Dima Hasao, 7.
They filed their affidavit.
Finance.
Finance has filed their affidavit.
Okay, Hill Areas Department.
Yeah,
But what about the councils? They are not there.
it is written as government affidavit. Government affidavit.
Actually, so I think I can proceed with the matter, hearing the matter. You call somebody from the NC Hills?
And for NCDs,
No, you called
yes,
Mr. R.R. Kaushik.
NCD standing down series.
Last time, sir, R.R. Kaushik appeal.
And that's. And that's.
The order reflects R.R. Kaushik for 5 and 7. Seven is Dima Hassan. 5 is Hapno. But NC Hills, I think they have not filed their affidavit. What?
Respondent number 7,
Inspectors.
Respondent number 7 is Dima Hassan, same.
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 Oh, same. Then Mr. R.R. Kaushik will appear. Okay, you can start. Even if he's not there, we will dispose it. Matter can be disposed of?
Yes. The petitioners are the employees of the high schools, my lords,
Hmm.
in the Dima Hasao district, NC Hills. What happened, my lord? They are serving on ad hoc basis. They are paid their salary, my lord, on ad hoc basis as per the minimum scale enumerated in the ROP 2010.
Ad hoc basis, perhaps basic, I mean the.
Basic,
pay.
basic, minimum basic. Great pay,
Fixed pay.
not fixed, great pay, and the pay band of first minimum amount that is paid only. And my lord, their appointments have been approved by the inspector of schools, and for years after years they have been continuing, my lord,
As ad hoc,
as ad hoc.
but their services are approved.
Approved by the inspector of schools, and
Okay. Now, if their services are approved, then what? Is it regularized, confirmed?
not regularized, not regularized.
They were extended from time to time.
They are not extended, they are continuing without their, as the services have been approved, they initially appointed with the school managing committee, and thereafter the appointments have been approved, and they have been granted the ad hoc payment monthly. This is
So
the status.
when were they appointed?
My lord, I have given the in the post title itself against their names. Like everyone's appointment, my lord, I have given against their name in the post title, my date of appointment.
Where?
3-1, suppose petition number 1, page number 6, he was appointed on 3-1-2002, my lord. Someone, say petition number 2, and on 11-1-2000.
Wait. When did you give it? Or date of joining?
Yes,
To some 2002,
yes,
2000,
2000, then 2016,
okay,
1991,
1991.
yes,
Hmm.
2003. Against everybody I have given, my lord.
Yes. So it varies from various dates.
And that's why I have given against their name.
Ah. And approval dates are also different.
Yes.
Yeah.
The main grievance is that, my lord,
Hmm.
in the state of Assam, my lord, there was Provincialization Act 2011, and thereafter Act was next in the year 2017. But during the period of those provincialization done in the state of Assam, my lord, the Dima Hasao has not been done. Dima Hasao there was no provincialization, my lord, since 2011. And the list I have given, my lord, in the page number 41. Those schools have been provincialized only in Dimahasa, page number 41, 91, 92, 96, 97, 98, and last in 2001.
These schools were provincialized.
These schools were provincialized. In the year of provincialization, I've given the chart, my lord. A type copy is the next.
But the petitioners working in the school is not.
Not provincialized. These are not provincialized, my lord. And after my lord, that I take, my lord, page number 43, annexure 2. This is the sixth schedule, relevant portion of the Constitution of India. As per this, my lord, they have been empowered to frame their own law, my lord. Accordingly, what happened, my lord, they have prepared a bill and submitted page number 58, 57.
Yes.
This is the bill they have prepared after the enactment of the 2000. This is the bill for 2018 to after amendment of the enactment of the 2017 Act, my lord. This bill has been prepared by Dimahasa in the year 2018 and forwarded, my lord, by the authority. The lordship will find page number 64. It is submitted by the Deputy Commissioner. The bill to the respond number 8, my lord. This bill is forwarded. Thereafter, the lordship will find it is written by the Commissioner, respond number 1, to the chairperson, Committee for preparing roadmap, including new acts and regulations pertaining to Education Department, Bamuni Maidan, Gauhati 19. This is forwarded to, this bill is forwarded by the Commissioner Secretary, the Second Education Department. After that, you also will find at page 68, annexure 6. This is the notification issued by the respond number, office of the respond number 1, my lord, Principal Secretary to the Government of Assam, Second Education Department, whereby the Government of Assam in the Second Education Department is pleased to constitute a committee for preparing the modalities for implementation of clause 6.6.3 of the recently concluded Borough Accord. The committee has been constituted. That committee, whatever, my lord, you will find page 70, annexure 7.
No, this committee terms of reference is what? Committee will suggest measures.
Yes.
Specialized schools and colleges.
Yes, in 6 schedule areas. That committee has convened.
But these are all BTAD areas.
Yes, BTAD area is includes also 6 schedule areas, my lord.
These are 6
Yes.
but not in case of Dimahasa.
Not particularly written as Dimahasa, but this notification is issued. And on the basis of that notification, my lord, annexure 7, page 70.
Yes.
A meeting has been minutes of the meetings of the committee constituted for provincialization of schools, colleges under 6 schedule areas.
Where did you find? Achha.
Page 70. After, at the outset of the meeting, the chairperson Seva welcomed the members such as after threadbare discussion. Next where I am reading, my lord, it has been decided as follows. A workshop will be organized in the district of Dimahasa for provincialization of schools and colleges. In the workshop, the details of relaxation to be done in the provisions of the Assam Such and Such Act on each of the section of the Act to facilitate provincialization of schools, colleges of Dimahasa district. The additional director Dimahasa Haflong will prepare a list of schools, colleges to be provincialized as per recommendation of the workshop as mentioned above, along with the with their financial implications, and will submit to the committee constituted by notification number dated.
So
There-
the workshop has to.
Yes, thereafter, my lord, annexure 8, this is the workshop meetings minus.
Then
This, as per this meeting, my lord, all particular schools attended, and the chart is at page number 73. It is as per this chart, you will also find it is continuing 73 to.
so the workshop referred
Yes,
They recommended for provincialization of these schools.
these schools and particular school, they have given recommendations.
So your school is not included here.
Our schools are included.
Okay.
Our schools are included. And then, my lord, it was forwarded next to page 78, annexure 9. It was forwarded to the chairperson again,
Okay.
as per his earlier decision, my lord. Thereafter, my lord, a notification has been issued, my lord, dated 11 January 2023, whereby government has, my lord, I'm reading from page number 81, my lord. Last paragraph. Now, therefore, in exercise of powers conferred under subsection ZD of section 2 of the Assam Education Provincialization of Services of Teachers and Reorganization of Education Institutions Act 2017, the Governor of Assam is hereby pleased to bring the venture education institution of 6 scheduled areas in hills districts under the purview of the Assam Education Provincialization of Services Act 2017.
So they brought these venture schools,
Yes,
institutions
under
under
the
the purview of this Assam Act.
Assam Act, my lord. But in this section, my lord, ZD, you also will find in the book, my lord.
Where is JD?
107. Okay, this book.
Here, no? Assam Act.
Education Minister আছে?
Assam Education Manual.
Page 107.
7.
Actually, this provision is inserted in this act, my lord, for the purpose of providing them special provisions for the regularization, because these NC hills or the 6 scheduled areas, they cannot compete with the general category, general schools, my lord. They need special provisions for their provincialization. Only for this purpose, this is inserted in this book, my lord. And in exercise of that power, this NC Hills Autonomous Body has prepared their bill and submitted it for their vetting.
ZD, let's see.
ZD, my lord. Venture educational institutions means and includes venture degree college, venture higher secondary schools, venture junior college, venture high school, venture high madrasa, venture ME school, venture ME madrasa, venture upper primary schools, and venture lower primary schools situated within the state of Assam, excluding the areas covered under the 6th schedule of the Constitution of India, unless a separate notification excluding the, this is excluded, my lord, unless a separate notification for inclusion of the venture education institution in such areas is issued and published by the government in the official gazette.
This is done. This
Yes, this has been done.
Ah.
As a result of this, my lord, what happened, you also will find in the next page 82. Page 82.
Approval for enhancement.
Approval for enhancement is separate, my lord. The director, my lord, has cancelled.
Ah.
This is connect. This is given in WPC, my lord, 6915, item number 46. I have given, my lord.
Tell me what is doing.
The director has cancelled the entire process of provincialization and entire recommendation on the basis that yes, the schools have been included directly under this main act, my lord. Therefore, they do not fulfill the criteria of the main act, and therefore these are cancelled.
So those.
The purpose of this section was to bring the special provisions for the provincialization of the schools belonging to 6 scheduled areas. But that is frustrated by including them making them at par with the general areas schools.
No. JD provides that if there is a notification for including
Yes,
those venture institution
yes,
of those
areas,
6 scheduled areas,
yes,
then government has to do it by notification. So
Yes.
that's been done.
yes.
Now you say that
The
the director has cancelled
cancelled,
the notification which brings those schools under the Assam Act.
yes. cancelled because as per this notification, the entire provisions of this act has been implemented. And once it is implemented, they are excluded because they cannot fulfill the conditions, general conditions of the act.
Before issuing the notification, those things has to be seen.
Yes, that is
That
not
is
seen.
fulfilled.
That is not seen, and the all the draft provisions, the draft legislation which is forwarded, that is not acted upon. They have, my lord, invited for meetings, and that is done according to them. After that, they have betrayed. That is the thing.
Now those venture institutions of the sixth schedule area are out.
Out.
From
In respect of
2017.
yes, if in respect of the Mahasab, they are totally out because they cannot compete. This is the reason. And my lord, on the other hand, they are not purely venture. Like other areas of general areas, my lord, their venture schools do not get anything, any financial aids, there's nothing they are getting. But the schools under the Dimahasao, my lord, they are given the minimum scale as per ROP 2010. Therefore, their status is not absolutely like that of venture school.
No, you said that they were continuing on ad hoc on
Ad hoc.
minimum.
Yes, they are continuing. Government is granting. You will find page number 82. This is the budget approval for enhancement of grant in aid in respect of 12 members of ad hoc high schools under Dimahasao district. These are the this is the budget of Malad 2020. Next, you will find again page number 84. These are the budgets. You will find basic pay is as per ROP 2010, 8,000, and grade pay. You will find 5,100. These are the scale. These are the scale of the ROP, and this, as per this scale, my lord, the annually funds are sanctioned, and the petitioners and the other teachers, they are getting the financial aid from the public exchequer regularly. Therefore, they are on the other hand, my lord, they are not like other venture schools.
So what have we challenged here?
In one
Exclusion.
one petition, I have challenged the impugned cancellation, and in this petition, I have prayed for enhancement of the financial aid, my lord, as per the ROP 2017, because now no longer there is ROP 2010, and it is replaced by ROP 2017, and as per ROP 2017, it is enhanced. So minimum scale in this petition I have paid, minimum scale should be paid as per the current rate, not as per the
2017.
yes, not as per the earlier one. This is the prayer in this writ petition, my lord. Because it is settled position. Recently, Honorable Supreme Court in various judgments has said, you cannot keep an employee temporary basis for longer period. And if they are serving like other regular teachers, they are producing human resource ballot every year. HSLC past 10 candidates are coming from their service. So, my lord, you cannot keep them exploiting for years after years. This is the settled legal position. You have to regularize.
Okay, I understand. Here, this is your case.
This
So
is the sum and
now
substance of the
you want
case.
the petitioners to be allowed the ROP of 2017.
17.
But and in the other petition, you have challenged the
Challenge the
cancellation.
yes.
So what the government has to say?
Lordship, I think we have to get our instructions and find our affidavit because the notification has been issued by by the school education, by us, by the government of school education. So
In the beginning only, I said that
Lordship,
I will hear the matter provided the government side do not come later and say all this. But now you're saying, you have
Lordship,
to- but affidavits are fine, I think they are so clear.
affidavit has been filed by the NC Hills, Your Lordship, and that affidavit will not suffice because what they have stated is that we have we have given the notification. That notification has been given by us, Your Lordship. So that we'll have to, since he has challenged the notification, meaning thereby he has challenged the rules, Your Lordship. Because by which the rules has been brought under the NC Hills.
What happened to the bill?
Lordship.
The bill that was submitted?
Bill, they know very well, my lord, what they have done, my lord. I have no idea because we have not been communicated with regard to the status of the bill as on date.
Lordship, and one more thing, Lordship, he says that the entire provincialization has been cancelled by 1/18 to 2023, and I cannot find him. It's not been annexed in
the other petition.
in the other petition as well. Which one?
691.
It's not here. Oh, that's not.
Now, who has filed affidavit? Let me see.
NC Hills has filed. Respondent number 7.
This
Inspector
is
schools.
reply. Respondent number 8 has filed.
7, I think, Inspector of schools. NC Hills.
Yes, Lordship. Inspector of schools have filed.
Yes.
Inspector of schools have filed, and you also have filed your reply
Yes,
to respondent number 8. So respondent number 8 has also filed.
yes. Respondent number 7 and my lord, the respondent number 8.
8 is who?
Respondent number 8.
Dima.
Director of Finance.
Finance have filed their reply. And 7 is the inspector of schools. So, Ms. Mushahari, you need to file an affidavit on behalf of secondary education.
Yes, your lordship, on behalf of respondent number 1. Because the MPO notification has been issued by the respondent number 1.
In item number 6915. Yes, I see the WPS number 6915, madam.
In Barun Center.
No.
Okay, you write it item number 48. That is WPC 1968. Third, Mr. A.K. Gupta, right?
B Purkast.
A protest.
B Purkast.
B protest. Learned counsel for the petition. And Ms. D. Mushahari, learned standing counsel secondary education. The petitioner in the instant petition has raised the issue that neither their school was provincialized, although a notification was issued to bring the schools of Dimahasa area, of 6th schedule area, the Dimahasa Katigama, of 6th schedule area, within the purview of Assam provincialization, Assam's education, provincialization of service of teachers, and reorganization of educational institution. Reorganization of Education Institution Act 2017. But later on, the same was cancelled. And also, the subsequent issue that the petitioners were not paid according to the ROP 2017, and they were made to work ad hoc basis since the day of appointment, which varies from date to date, of which varies from the year 2019 to 2022. Or there are
1991 to 2002.
or 1991 to 2022. The Learned Council for the Secondary Education, however, requires some time to file the affidavit and praise for the same. Prayer is allowed. List this matter well.
After
Let's just-
B.
To keep on going on, you please file your affidavit. Release this matter on 22nd of April. Before which the Learned Council for the Secondary Education would file their affidavit without pay. All the 3 petitions you write the same order. Okay?
I'm sorry, my lord, I information for item number 45, my lord. That was fixed on 9, my lord. The 9 and 10 was declared for
Oh,
holiday.
45.
9 in 45, item number 45. my lord.
Did I fix it on 9?
Mm,
Have you fixed it on 8?
Not 45, I don't know 45, like 9 and 10 was declared holiday.
So I'm telling you, we'll fix it on 8.
On 8, I will not be able to.
Then after Bihu,
After before or before 8, madam?
28 of April.
Madam, no. Take care.
Lordship,
49 and 50 years.
Lordship, my senior is currently on legs. If it may please your honor, if you may please your lordship, may the matter be passed over for the time being.
After subject. Mr. Gauhati.
Lords. It's a matter relates to transfer of them of two employees, your lordship.
Transfer.
Transfer of this.
Should I entertain? Transfer is an exigency of service.
Lordship, since your lordship, I am obtaining I have already obtained a stay order, it is better to dispose of the matter. Admitting it will help me, but your lordship.
This transfer is a condition of service. You
Lots.
should not actually challenge it.
Lords,
Of course, unless you can show some biasness or.
lords. That is what I will try to show. More than that, your lordship, so far as transfer is concerned, your lordship, it is an incident of service. And it will be at their discretion, your lordship, no doubt about that.
And respondents are represented.
Very present.
I can take it for disposal.
Yes, lords.
Otherwise, normally what happens, government sides comes and say,
Probably one aspect is there, your lordship. Yeah, I don't know whether record is available or not, but the record will be necessary since your lordship affidavit has not disclosed the reason why this transfer has been effected. Your lordship. That record is probably.
record is there.
Yes.
Buddha Google. He's here today. Let him come over. Or I can proceed. He will come.
Lordship, as per your lordship.
Records are here. Mr. Saikya, you are.
I'm for a private estimate.
Then I can hear.
No. Your lordship, the petitioner, your lordship, he is then your lordship employee under Sarva Shiksha Abhijan mission, your lordship. And as your lordship knows very well, these are all contractual employees, your lordship. Initially, he was with the under the district primary education program. Once your lordship, that program has been abolished and the Sarva Shiksha Abhijan was introduced to your lordship scheme under Sarva Shiksha. He was absorbed and was appointed your lordship as a district program officer. That is ECNI, Inclusive Education. That is in the year 2001.
Where is his appointment order? Was
Your lordship. Appointment order I have not annexed, but your lordship, I have made a statement to that effect, your lordship. In para 3, your lordship.
Yes, Mr. Gogo, you are here.
Yes.
Can I hear it for finally? Finally.
Basically, 5% damp. We have now
Let's see.
Lordship.
Where do we fight for?
Lordship.
Acha, so you are Roman Meji.
Roman Madhya, lordship.
Huh.
Your lordship, I have made your lordship, and then your lordship will find your lordship. He was, then your lordship petitioner was in 2001, your lordship, appointed in the transferred to Sonitpur district and appointed as a district program officer in ECNI. Then your lordship from Sonitpur.
Acha, 2001, he was transferred to Sonitpur district.
Sonitpur district as district program officer in ECNI, Inclusive Education. Then your lordship will kindly come to page 14. That is, that in the interest of SSA Assam, Sri Jiti Bonia so-and-so, district program officer Morigaon is hereby transferred and posted to the district mission officer SSA Sonitpur in the same capacity against Sri Roman Medhi, district program officer Sonitpur.
So Mr. Saikya is representing Jyoti Bonia.
No. This was your lordship 2006.
Acha.
This is the history, your lordship. Now he was your lordship brought to Morigaon in 2006.
Mm.
Then in 2010, he was transferred to Dhemaji, Your Lordship.
Achha, wait. The second paragraph, Raman Medi, District Program Officer,
Lordship.
transferred and posted to District Mission Officer, Morigaon,
Morigaon.
right?
Right.
And Riti Bonia was brought to Sonitpur.
Sonitpur. There is no
Yes.
dispute with that, Your Lordship. And accordingly, I joined. And in 2010, I was taken to Dhemaji, Your Lordship, in the same post.
Second page, next page.
Next page, Your Lordship, will get.
District Program Officer. Okay. Mm.
Lordship. Then, Your Lordship, after that, Your Lordship will kindly come to page 17. Before that, he was from Dhemaji in 2016, who was brought to Sonitpur again, Your Lordship. And while he was in Sonitpur, Your Lordship,
He was brought to Sonitpur again.
again, I have not annexed the order, but Your Lordship, I have made a statement to do.
From Dhemaji to Sonitpur.
Sonitpur.
Then
Then on 23/9/2024, from here, Your Lordship, the issue
page
starts.
number 17.
17.
Ah,
Your Lordship will find that serial number 6,
Anupam Sharma.
respondent number 4,
Mm,
he was in Goalpara,
mm,
he was brought to Dhuburi.
mm,
And then page 18, Your Lordship will find
mm,
serial number 14,
mm,
Roman Medhi, District Program Officer, Sonitpur, brought to Goalpara,
mm,
Your Lordship, and I joined.
mm,
And he also joined in his post.
mm,
Now, all of a sudden, Your Lordship,
mm.
it was from 23/9/2024 to 16/10/2025,
Mm.
which was, Your Lordship, within 1 year, Your Lordship. After 1 year, Your Lordship.
23/9/24.
Then 16/10/2025. In the interest,
1 year.
beyond 1 year, just past 1 year. In the interest of public service and for smooth implementation of SSA activities, Anupam Sharma so-and-so, Dhuburi district is hereby transferred and posted as SSA Goalpara district in the same capacity. Roman Medhi, DPO so-and-so, Goalpara district hereby transferred and posted as SSA Dhuburi district in the same capacity. Now, Your Lordship will kindly note, Your Lordship, that the transfer at page 17, where normal transfers, Your Lordship, not only the petitioners, Your Lordship, different officers were, Your Lordship, transferred to various places. Your Lordship. That's a shifting. And this is an isolated order, Your Lordship. Here only one case was considered. Your Lordship. Now at that point, I have come before this honorable court. I have also submitted a representation at page 20, Your Lordship. And during that period, I came before this honorable court, and my case was that, Your Lordship, this transfer is not at the public interest. Ultimately, in public interest, on administrative exigencies, the authority can always transfer a person. But here is a case, Your Lordship, in my humble submission, I will show from their affidavit itself, Your Lordship. This is not a case, Your Lordship, where these aspects has been considered by the authority. Just to accommodate this private respondent number 4, I was transferred back again to Your Lordship Dhuburi, and he was brought into Your Lordship Goalpara, Your Lordship. Your Lordship, that was my case. And apart from that, I have prayed that I have only few years of service left. At this stage, I should not be transferred. That was the 2 grounds. Now, Your Lordship will kindly come to the IA filed by the respondent number 4. It's IA number 3717 of 2020. I will be there.
Vendor. Yeah. So your basic challenge is to that notification,
Lord, that order, Your Lordship.
that order,
Lord.
transferring you to Dhubri. I 3717.
3717.
This I is filed by
Private respondent for vacation of the stay, Your Lordship. Now, Your Lordship, may kindly one paragraph, para 3, Your Lordship. He has disclosed the reason why he was transferred back, Your Lordship. The respondent number 4. It is not the authority who has disclosed the reason. The respondent number 4 himself, Your Lordship. That the applicant begs to state that on 23/9/2024, he was transferred from Goalpara to Dhuburi. At that point of time, father of the applicant, who was aged about 90 years, was bedridden as he suffered a brain stroke on 25/8/2022. That means, Your Lordship, his father resides in Dhuburi, probably. Therefore, considering the health condition is
They resided at Gwalpara.
Gwalpara, sorry, Gwalpara. At that point of father, the applicant who was aged about 90 was bedridden as he suffered a brain stroke on 25/8/2020. Therefore, considering the health condition of his father, the applicant submitted a representation before the respondent authorities on 10/11/2024 to transfer him to Gwalpara by sympathetically considering the health condition of his father. Subsequently, on 22/5/2024, father of the applicant breathed his last. In the meanwhile, 12/2/2025, unfortunately, the applicant had also met with an accident which he suffered from serious head injury with fracture on his parts. Still, applicant is fully not recovering and sometimes he is facing severe headache also. The distance from his house to Dhuburi more than 110 km and to Gwalpara 55 km. Moreover, applicant's wife is also diabetic patient requiring regular checkup. The son of applicant is also appearing in the HSLC examination in the next session, requiring the constant care from the applicant. As such, he approached the authorities again to transfer him to Gwalpara. Considering his grievance, the respondent's authority, being a model employer, transferred applicant from Dhuburi to Gwalpara on medical and humanitarian ground. There is no illegality in transfer order that is so and so, and the same has been passed on the aforesaid facts and circumstances. If the writ petitioner is aggrieved by the said transfer order, he can approach the authority concerned to accommodate him any suitable place without affecting the applicant. Be it mentioned herein that resident of Kamrup M and a post of program officer is lying vacant in Amingao. If the petitioner is interested, then he can approach the authority for modification of the transfer without affecting transfer of the applicant. Now, your lordship will kindly see that it is clear from the statement made by the writ petition, respondent number 4 itself. This is not in the public interest, your lordship. When it is not in the public interest, your lordship, you have transferred me 1 year back from Somitpur to Gwalpara. I have settled down there. And suddenly, at the instance of the respondent number 4, you have transferred me back again to Dhuburi just to accommodate him in Gwalpara, your lordship. That is why, your lordship, it is a fact that what has fallen from your lordship's mouth at the initial time, the transfer is an incidence of service. They have the discretion. But how that discretion will be applied? Even if you have decided to go for that, you should have at least asked me for my views, your lordship. Because had it been a case, a general transfer in public interest on administrative exigencies, then yes, I don't have any case. But if it is a case, you are accommodating someone and on the basis of his application, and by the time they have transferred him, his father has already breathed his last, your lordship. Now, in the meanwhile, his son has also appeared in the matriculation examination. That is also over. Now, these cannot be the consideration. If your lordship, I cannot pray before this honorable court or the authority before the authority that my transfer should be stopped on this ground. This cannot be ground also for transferring another person at his request, your lordship. Therefore, your lordship, my humble submission is that this transfer is not in the public interest, not in the interest of and not on administrative exigencies. It is purely to accommodate this person as admitted by him himself. Your lordship, this has been done. Now, the authority has also filed their affidavit. Your lordship. Your lordship will kindly see their affidavit
In the writ,
by respondent number 3, your lordship.
in the writ or in the IA?
In the writ, your lordship. And in fact, your lordship, prior to that, for 10 years, the respondent number 4 is all along, your lordship, in Gwalpara. Just for 1 year, he was transferred to Dhuburi. Then he again want to come back to Gwalpara. There must be some interest involved with him. And your lordship, it is not. I am from Kamrup, your lordship. I have accepted my transfer to Dhuburi, your lordship. I have not prayed for shifting back to Kamrup. That is not the case. My case is that I have obliged every transfer order that has been passed, your lordship. I have never objected to, I have never applied for. Now, when a man from Kamrup was transferred to to Dhuburi, he can accept it just to accommodate a person who is 55 kilometers and 100. This is, if it is a incidence of service, it is an incidence of service for him also, your lordship.
Now,
Why
what did
only
the-
me?
What did the respondent number 3 say?
Lordship will kindly see their affidavit. They have not said anything.
Response number 3 is the server section.
Your Lordship. Para 4, page 25 onwards, Your Lordship. The deponent further humbly begs to submit that the petitioner or, for that matter, and any employee of the government has no vested right to remain posted at a place of his choice. Only he has, Your Lordship. Respondent number 4 has vested right. That is why on his application, he was again transferred back to Goalpara, Your Lordship. He cannot insist that he must be posted at one place or another because no government can function in such manner. A government servant is liable to be transferred as per the administrative requirement from one place to another. Transfer of an employee is not only an incident inherent in the terms of appointment, but also implicit as an essential condition of service in the absence of any specific indication to the contrary. It seems that the petitioner is trying to make out a case of discrimination against him, whereby he had arbitrarily discriminated against and singled out for harsh treatment in preference to his colleagues similarly situated, which is not correct. In this regard, order dated 23/9/2024 and closed as Annexure 3 of the writ petition may be preferred. By the said order, 15 numbers of TTPs were transferred and posted in different districts as per administrative requirement, and petitioner is one amongst them. I have no grievance against that order, Your Lordship. He was not singled out for a harsh treatment in preference to others as projected to be. As per Assam Sarva Shiksha Mission, Abhijan Mission Service Regulation 2003, which governed the terms and conditions of service of the employees of contract in mission service, a member of service engaged either on contract basis or on deputation attachment shall be liable to be posted anywhere within state of Assam or any other department or government, corporate body, society in the affairs which the mission may be interested, and in such cases the member shall have no opinion against such posting or transfer. Further, as per Regulation 6 of SR 2003, all contractual employees will have to sign an agreement. Accordingly, the petitioner signed an agreement with Assam Sarva Shiksha Abhijan Mission and thereby duly executed the terms and conditions stipulated in service contract agreement. As per clause 8 of the said agreement, during the tenure of contract period, the party of the second part may be posted at any place within territory of state of Assam. Needless to say, the petitioner is amenable to Regulation 6P of SR 2003 by operation of clause 4 of the service contract agreement, which provides that during the subsistence of the contract, the second party shall be subject to all rules, regulations, bylaws of the Assam Sarva Shiksha Abhijan Mission for the time being in force in all regards, including conduct and discipline. Therefore, to approve the contractual terms in one proceeding and then to reprobate in later proceeding is not permissible under law. The authority in Assam is well within its power, competence, and jurisdiction as per law to transfer any member of Assam service, let alone the instant petitioner anywhere within state of Assam, and the member shall have no option but to join his new place of posting.
Is for number 3?
Till
Gogo is there.
You know, we will get out of state.
No. He has not finished. I'm just asking.
Yes, yes.
You are for response number 3.
Yes, the service shall be done with the.
Your turn will come.
now, Your Lordship will kindly see here they have not dealt with the why that transfer is necessitated, Your Lordship. That has not been dealt with.
They have given the general
General things, Your Lordship. That I have no quarrel with that, Your Lordship. These are the proposition established principles of law in service jurisprudence. There is nothing. My whole case is that this is not in the public interest. They are to show to this court, this honorable.
Sometimes even the personal interest have been taken note of, right, in transfer matters.
That can be, Your Lordship, but
That can be done in respect of response number 4.
Lordship,
As
but
far as you are concerned.
yes, Your Lordship, why me, Your Lordship? That's the issue, Your Lordship. After 1 year,
Somebody has to be transferred to the post that
Lordship,
is holding.
and Your Lordship, that they can always do, but they have singled me out, Your Lordship, out of this, Your Lordship. Why me, Your Lordship? Why it is so pressing for them to bring him back again to the Goalpara, Your Lordship?
He has his personal reasons for that. So he must have made representation that is allowed.
Lordship,
But somebody has to go and take his place.
Lordship,
So it's
why?
up to you. Somebody has to
Lord,
go.
that is why, Your Lordship, they will have to show that why I am, Your Lordship.
But whether you are required to be heard before.
Lordship, my case is that, Your Lordship, that normal cases need not be heard, Your Lordship.
Huh.
But here is a case, Your Lordship, that when they have exercising their discretion, Your Lordship, to my detriment, whether I am entitled to be given a hearing or not, Your Lordship. Because, Your Lordship, had it been because that is why, Your Lordship, Annexure 3, where the general transfer is concerned, that I cannot have any objection. And I have accepted it. I have never said that I should not be brought from Sonitpur to Your Lordship,
No,
Dhuburi.
see, he was transferred because of his, as I said, personal vision. He also make a representation that, but then challenging his transfer.
No, ultimately, Your Lordship, unless I challenge that, Your Lordship, where will I go, Your Lordship? I have settled down in Dhuburi for just 1 year back, Your Lordship. And from
He
Sunit
settled down in Gwalpara.
Gwalpara, Your Lordship, for 1 year back, Your Lordship. All of a sudden, Your Lordship, that I will have to again go to Dhuburi, Your Lordship, which according to him itself, Your Lordship, another 55 kilometer, Your Lordship. 13 months of service in one place, Your Lordship. Therefore, Your Lordship.
There is no bar.
No,
That
there
cannot
is
be
no
done.
bar, Your Lordship. Generally, these transfers are not effected within 1 year, Your Lordship. Your Lordship has seen, Your Lordship, after 5 years, 10 years, 3 years, that normal transfers are being done, Your Lordship. But here is a case, Your Lordship, where they have deviated from that principle so far as I am concerned. So when
This is not a case where authorities have acted illegally or for some other reasons.
that I don't know, Your Lordship. That will be disclosed by the record, Your Lordship. Since the affidavit is not clear, Your Lordship. That Your Lordship will have to go through the record, Your Lordship, and see. But the point is, Your Lordship, it may not be illegal, but it is arbitrary, Your Lordship. Arbitrary in the sense, Your Lordship, that the ground which the respondent number 4 has shown, Your Lordship, non-existent ground, Your Lordship.
Where is this one number 4's affidavit?
His
Here.
IA, Your Lordship.
Okay, that is your case.
That's my case, Your Lordship.
So what do you say, Mr. Gogos?
And I have only 1 year of service left, Your Lordship, in the meanwhile, Your Lordship.
You are retiring next.
Yes, Your Lordship. At the fag end of my service career, they have, Your Lordship, to accommodate respondent number 4. Then again, I was shifted to, and 6 months is already gone, Your Lordship.
That was, of course, a ground
Lordship.
at the fake end of the career.
Lordship. Your
One
Lordship
not-
will see the
As a
record, and Your Lordship will.
So far as the petitioner is concerned, madam, he is the employee, madam, under respondent number 3. And respondent number 3 being the model employer. He is a contractual employee, not a regular employee.
Acha, services are all contractual
Yes.
employees.
There is a society, it's a registered society. So, madam, there is no such transfer policy like that of the state government, where, madam, the minimum tenure, otherwise, madam, is 2 years. Earlier it was 3 years, now it is 2 years. Before that, some approval of when the chief minister is required. Here, there is no such policy. In fact, there is no stand of the petitioner that there is a policy, and in violation of that, within the period, my lord, say 1 year, 2 years, he is supposed to remain in a particular station. He has been transferred out, violating our own policy. That's not his case. But here he has made a statement that he has remained there for 13 months. Thereafter, my lord, again he was transferred. And in the transfer order, it has been stated that it is in public interest. Because to accommodate someone will have to leave. Now, my lord, if we see the protection.
Somebody has to
Yeah.
go.
Now, if we protect the petitioner, then another third person will have to be transferred. He will come again, my lord. Again, my lord, what she will have to consider that. Then it will be a never-ending process. Only thing is, my lord, let him join in his transferred place. Then he can represent, my lord. He can.
That is what I said you-
That I am going to retire.
Presentation.
Kindly look into this, and within a time frame, my lord, they will consider if it can be brought to a nearby station, to his hometown or anything, my lord, possible. That will have to represent. He has directly, my lord, on that point, my lord, at least he can represent before the authority after joining in that particular place of post.
So I don't see anything.
And in fact,
biased
my lord,
against
the
you.
ruling of the Honorable Supreme Court to that effect, that first he must join, then he can represent. Very first time he cannot come and take a stay, because that it unsettles the entire position. Other side is hanging. He is taking a stay for last 6 months. He has thus not stated. Transfer posting for last 6 months he is holding in the place where there is no authority at all for him to stand. That's because, my lord, the Honorable Court has given some protection.
Respondent number 4 is still in Dhubri now.
Yes, my lord. So this is the extent, my lord. Otherwise, my lord, we have stated that in the agreement that he has signed, it is categorically stated that he will have to go wherever he is posted by transfer. He has signed it, my lord. He is a contractual employee. He cannot have those protection like a government employee, where there is a scheme as a status. So this is our stand, my lord. We have given it, be it for somebody, because it will have to be a vice versa transfer. Transfer is always vice versa.
Records will show anything.
Well, records, whatever we have said in the affidavit, that is there, my lord. And so
Representation by R4, and it was
of
considered.
course it is there, my lord. And in fact, he has on his own, the respondent, private respondent has genuinely, my lord, spelled out everything. That's for this, I was found. So bona fidely, my lord, everybody has, my lord, placed it before his honorable court. I leave it to your lordship. But, my lord, my humble submission, let him join. and you represent before the authority, lordship will direct the authority to consider it in a time frame.
Like it is
If the
done in this
genuine grounds,
case.
my lord, they will consider being the model employer.
And how long is he going to continue? I mean, when is your retirement date? Are you in the verge of retirement? No, no.
No, that is not his problem.
And that's what you have said in the affidavit. So your stand is that I had filed my representation, it was considered and I was brought here. And in my place, he was sent. Anybody could have been sent. This is what you stand on. So what I
One
think,
more
Mr.
step,
Bottom,
my lord,
you
one
go
that
and
regarding my
give a
hearing part.
representation.
That statement regarding hearing, my lord, that my lord, with the consent of the employee, if transfers are not made, my lord, then there will be no transfer at all. Normally we give the hearing
Everyone-
I am not,
Go-
no, your lordship will
on
kindly see.
that point, my lord.
I have
That's
objection.
what I'm saying, my lord. If
I
you
am
have
not
a-
saying that in every transfer I need to be heard. That is why I'm, so far as Annexure 3 is concerned, this is general transfer in the public interest, in the administrative exigency. There is no question of your lordship hearing me. But I am telling your lordship, submitting before this honorable court, that when that is not the case, your lordship, it is at the instance of someone to accommodate someone, admittedly, your lordship, not in the public interest. Supreme Court says, your lordship, when it is public interest and administrative exigency, we don't have any case, your lordship.
See,
But your lordship will also have to see, your lordship, whether the grounds for transfer after remaining there for 10 years, your lordship, then going back to Dhuburi, then for the grounds shown by him, whether these grounds are serious enough for an employer to transfer an employee at the detriment to the another employer. That your lordship will have to see.
detriment to
Lord.
another employee means it can be you or someone else.
Lordship, that is what your lordship.
Normally, like, I have seen cases where the ministers interfere and then he makes transfer of somebody here and there.
No,
But in this case, there is no.
no, your lordship will kindly see. The nowadays, your lordship, Supreme Court has said, your lordship, that even if minister and employees interfere, then also transfer cannot be challenged, your lordship. That is no question about that. But in the present case, your lordship, that is not my case at all. My case is that, your lordship,
Not in public interest.
not in public interest. It is at the private interest, and that is to detriment of my interest, your lordship. That is my case, your lordship.
You go and join and make.
That your lordship will kindly see, your lordship, that's my ultimately what will your lordship will pass an order, your lordship. I will have to abide by that, your lordship. No question about that, your lordship. But this is my submission, your lordship, whether consider it is good enough to interfere or not, that's for your lordship to decide. But my point is, your lordship, that this is not being in public interest. It is purely in the private interest. And that too, after 10 years he is remaining in Goalpara, he was again brought back to Goalpara, and his home district is not Goalpara, it is Bongaigaon, your lordship. Your lordship will kindly note. It is not that his home district is Goalpara. His home district is Bongaigaon. And my home district is Kamrup, your lordship.
In his parents and his wife stays at Bongaigaon.
I don't know, but your lordship, his home district is Bongaigaon, your lordship, not Goalpara, your lordship. But that being the position here, why is so much interested in Goalpara, your lordship? There must be something, your lordship, which can anyone draw some inference, your lordship. I will not, I don't have but the manner in which the transfer is effected, the transfer is done at when, your lordship, people are filing representations after representation, your lordship, those are not considered even in the genuine grounds by the authorities, your lordship. Here is a case, your lordship, where this was considered, your lordship, and the one ground on which he is seeking transfer, that the health condition of his father has in the meantime, your lordship, breathed his last, your lordship. Even then, your lordship, the government is, your lordship, hell-bent on transferring him back to Goalpara, your lordship. That is why I am submitting, your lordship. Your lordship will go through the record, and these are my submissions. If your lordship find it good enough to interpret, your lordship will interpret.
Records what needs to be seen. They have already.
Because your lordship, authority has not disclosed the reason in the affidavit. Affidavit is general in nature. One cannot have any quarrel with that, your lordship.
Acha, anything more, Mr. Gogoi?
Why that has been said?
This my
Only that
submission.
representation was considered.
But that is clear in the affidavit. We have stated that, my lord, considering the public interest, he was transferred. That is there
Just give
mentioned.
me that record.
So no, but in the affidavit, whatever is there in para 4, we have made categorical statement in that regard.
Why
Four
the
and eight.
record, your lordship, is placed, your lordship?
4, 8, and 10, my lord. That's why our.
Why they are shy of producing the record before this honorable court, your lordship?
My lord, for 6 months,
In every transfer cases, your lordship, honorable courts, your lordship, always produce the records, your lordship, see the what necessity. And that too, when they are not, they have not come clean on the reason why this has been.
This case is different. This is
No,
Sarva Shiksha contractual.
Your lordship, in most of the, most of the employments are in Assam or any other state is now becoming contractual.
No, this is the wrong
That-
statement.
that-
How
that-
can be? Most of the.
That in schools, last a few minutes back, your lordship, there is a case for regularization, your lordship has seen. Large number of teachers are contractual in every department, but that will not give them a, your lordship, that wide power to your lordship transfer without following any rules and procedure, your lordship, norms.
Question of
And your
reference
lordship
to
will
the
kindly see,
service
even in the case of state government employees, if they are, your lordship, 2 years minimum period is given for them, why not, your lordship, for these people, your lordship?
This is
What-
what the government
That
decides.
That is why I am not taking that ground, but your lordship,
It's
I
okay.
leave it to your lordship. Your lordship.
Who has given this judgment?
6 and 9.
But Mr. S. Waterford, learned counsel for the petitioner, and Mr. D. B. Gogol, learned standing counsel, Sarva Shiksha. Standing counsel, Sarva Shiksha. Standing counsel, Sarva Shiksha, Abhijan, something like. Sarva, Homogra Shiksha. Homogra Shiksha. Hmm. And Mr. I. H. Saikya, learned counsel for respondent number 4. The case of the petitioner is that the petitioner was appointed. Do we say appointed?
Engaged.
Engaged. The petitioner was engaged. No, the petitioner was initially appointed under the district primary education program in the year 1998 in Borpeta district. And thereafter he was transferred in the year 2001 to Sunitpur district as a district program officer in ECE and IE, inclusive education department under the DPEP. What is DP? Oh, district planning. Okay. Under DPEP. The petitioner further states that on 3rd of July 2023, the DPEP was winded up by the government and the petitioner, along with others, were absorbed in Sarva Shiksha Abhijan mission, which is later on changed to Homogra Shiksha Yojana and was posted at Sunitpur. Also, the petitioner thereafter was transferred and posted to District Mission Office, SSA, Morigaon. Dated on 20th June. By order dated 20th June 2006. Thereafter, again on 5th of August 2010, the petitioner was engaged as district program officer within bracket teachers training in the vacant post of SSA, Hemaji. Also, the petitioner was again on 23/9/2024 was transferred and posted. Was transferred from Sunitpur. From Morigaon to Sunitpur, what happened? In between, Mr. Bhattakur, he was transferred to Morigaon.
Morigaon.
Thereafter, Morigaon to Sunitpur.
Dhemaji.
Or Dhemaji. Dhemaji to Sunitpur.
Sonitpur.
Thereafter, the petitioner was again transferred from Dhemaji to Sunitpur
In 2016.
in 2016.
Lots.
In 2016. And thereafter, by order dated 23/9/2024, the petitioner was again transferred from Sunitpur to Gwalpar. Whereas, by the same order dated 23/9/2024, respondent number 4 was transferred from Gwalpara to Dhubri. It be stated here that order dated 23/9/2024 was not in respect of the petitioner and respondent number 4 only, but in respect of many employees who are working under the Samagra Shiksha Yojana. Till then, the petitioner was not aggrieved by the transfer and posting given to him at various places over the said period of time. However, on 16/10/2025, that is, after a span of 1 year, 1 month, 1 year, 1 month, 1 year, 1 month, the petitioner was again transferred and posted at Samagra Shiksha Abhijan, Dhubri district. And respondent number 4 was transferred and posted at SSA, Gwalpara district. It is this order that the petitioner is aggrieved with. It is seen that the petitioner was transferred from Gwalpara to Dhubri district by the said order, and the respondent number 4 was transferred from Dhubri to Gwalpara district. The petitioner agreed by the said transfer order, made representation before the mission director, Samagra Shiksha Akhom. I said Abhijan, no? All of Akhom. Stating inter alia that it has been only 1 year, 11 days of his working in Gwalpara district that he was transferred. It's okay. Gwalpara district. He was transferred from Gwalpara district to Dhubri district. And further that he was left with only 18 months of service. And that during this peak end of his service career, he was again transferred to a place which is far off from his hometown of Kamrup. Mr. S. Botakur, learned counsel for the petitioner, submits that the petitioner was transferred from Goalpara to Dhubri before completing even 2 years of service in Goalpara, and that he is at the verge of retirement, and that he was transferred to such far off places. And he submits that the said transfer order was not in public interest, neither in exigencies of service. Which is required in case of transfer of any employee. Mr. Botakur has referred to the affidavit filed by respondent number 4. Where have you shown that
There are three, Your Lordship.
the respondent
I, Your Lordship.
three affidavits
No, Your Lordship. I of the respondent number.
has referred to the interlocutory application, has referred to the interlocutory application filed by respondent number 4, in which at paragraph 4, no, in which at paragraph 3, respondent number 4 had stated that when he was transferred from Goalpara, his father was 90 years of age and was bedridden, as he had suffered from a brain stroke on 25/8/2022. And that the respondent number 4 had made a representation before the respondent authorities on 10/11/24 to transfer him to Goalpara. Taking into account the health condition of his father. He further stated that although his father expired on 2/5/2025, he had met with an accident and his legs, and he had met with an accident and suffered a head injury with fracture. And that his wife was also suffering from some disease, and that his son was also appearing for some examination. And considering his grievances, respondent number 4 was transferred from Dhubri to Goalpara on medical and humanitarian reasons. Full stop. He as such submits that there is no illegality in the transfer order dated 16/10/2025. Transfer order is 16/10, right? 16/10/2020. Respondent number 4 also stated that he has no grievance against the petitioner and that the petitioner can also make a representation to the authorities to transfer him to suitable places. Question. The learned counsel for respondent number 4, to substantiate his argument, has also placed a judgment of the Honorable Supreme Court passed in SC Saxena versus Union of India. Oh, no. I said it was his submission, but what of the submission? He has placed, no, it is a by referring to the asset contention of respondent number 4 in the said interlocutory application, Mr. Botako submits that the said transfer order dated 16/10/2025 was not in public interest. Full stop. As such, the learned counsel prays that the said order may be interpreted and the petitioner may be allowed to remain in Gauhati in the last days of his service career. Full stop. Parent. Mr. B. Gogoi, learned counsel for SSA, by relying upon his affidavit, had stated that the services under the Samagra Siksha Ahom is in the nature of contractual service, and that the employees has to join their services at the place of posting and should follow the transfer orders. He submits that the respondent number 4 had submitted representations showing the health condition of his father and his family members and other humanitarian visions. And as such, he was transferred from Dhubri to Gwalpara. And in view of the fact, somebody has to go and join at SSA Dhubri, the petitioner was sent. And there was no illegality in the order. Neither there was any biasness on the part of the authorities. He further submits that if the petitioner is agreed with the transfer, he can first go and join his place of posting and then make representation to the authorities who would consider the same as it is considered in other cases. He also submits that under the law, it is required that the employee has to go and join his place of posting. And that The same principles does not apply to the employees working under the Samagra Shiksha account, like in cases of government service. Mr. I. Saikya, Mr. I. Saikya, Learned Counsel for Respond number 4, has reiterated the statements made in the affidavit, in the interlocutory application by stating inter alia that on humanitarian and medical reasons, he was transferred from Dhubri to Gwalior. He has placed the judgment delivered by the Honorable Supreme Court in SC Saxena versus Union of India and others, reported in 2006 9 SCC 583, by which the apex court has held that a government servant cannot disobey a transfer order by not reporting at the place of posting and then go to the court to ventilate his grievances. It is further held. Ventilate his grievances. I've heard the parties and have gone through the records of the case. It is not, it is noticed that the petitioner is working as a district program officer. No, is working as a
DPO, your district program officer, your lordship.
district program officer within bracket IED and ECE bracket close.
Now your lordship, teachers training.
Oh, which is teachers training. District program officer within bracket teachers training. At assessing under the scheme of Samagra Shiksha Assam. And he has been working in the said capacity since 2006, after he was absorbed under the said scheme. During his service tenure, he was transferred to various places and he has joined the said place of posting without any objection. But when he was transferred to Dhubri district by order dated 16/10/2025, by bringing respondent number 4 from Dhubri district to Gwalior district, he felt aggrieved. And after filing the representation, came before this court by filing the instant writ petition. It is no res integral that an employee / government servant can challenge the transfer order on grounds of some biasness in case of the authorities concerned. Or on some other genuine grounds. The employee or the government servant has to join the place of posting on being transferred by authorities. When we said transfer order, is due to exigencies of service. It is noticed that respondent number 4 had represented before the authorities concerned about his problems / issues faced by him if he is made to stay in Dhubri district, and the authorities concerned on finding the reasons genuine had transferred him from Dhubri to Gwalpara. Further, the transfer is an incidence of service which cannot be disobeyed by an employee Full stop. It has been held by the Supreme Court that an employee, when transferred, has to first report for work where he is transferred, and thereafter make a representation as to what may be his personal problems. And the authorities are duty bound to consider the same. In the instant case, the respondent authorities had taken into account the personal problems of respondent number 4. And while bringing respondent number 4 to Gwalpara district, one of the employee has to be transferred to Dhubri district from where respondent number 4 was transferred. And if it is not the petitioner, it has to be someone else. As such, no illegality is seen in the order dated 16/10/2025. It is accordingly directed that the petitioner should first go and report to the place of posting at Dhubri district. And if required, he may file a representation to the authorities showing his personal problems, which would be considered by the authorities. It is also directed that on such representation being filed, the authorities would consider the same within a short period of time, since the petitioner has only few months left, few months or year, only a small span of time left.
There on 14/3/2029.
Or 29.
But your lordship, 60 years is will be in your lordship.
You said 18 months?
Lordship.
You
60 years you will cross 60 years, your lordship, after 1 year, your lordship. That's what my instruction will be.
But then in the representation you wrote?
That's 18 months at a relevant point of time. Now, 60 years.
within a reasonable point of time, within a reasonable period of time. They consider, no, of course, sir, within a reasonable period of time. As the petitioner has only few years left in his service. Accordingly, the petition is dismissed. Uh-huh. Yeah, the interim order stands vacated.
Deeply obliged, Your Lordship. On the date of filing of the petition, 58 years, Your Lordship.
Yes, also.
2 years. 2 years. At that point of time, 18 months, Your Lordship. Now, 6 months done in the meanwhile.
So not many years, you said 29.
Perhaps one of their service is 62 years.
That-
His date of retirement is 29 months.
Oh,
Gross.
so
Gross.
petition was dismissed and disposed of.
What?
Or you don't want to write?
No, Your Lordship can write it. This once dismissed, it is dismissed. Your Lordship.
and disposed.
What is that? Deeply obliged.
Yes.
Order to forget.
It take me matter of, 41, right? Mr. Dasgupta, your matter is 43. 43. 42, 43. Okay, 41. Who is appearing in 41?
I forget whether this one.
I'll take up his matter and then I'll take the case. Okay, 42, 43, yes, Mr. Dasgupta.
But in this case, my lord,
Ah,
respondent authority
have not filed any affidavit. Sometime between you are for social justice.
no, on several occasions, the matter was adjourned.
Hmm.
We have not yet filed the affidavit.
It's we received instructions, but we need some time. Why not? Here for respond number? No one has filed affidavit, it seems, right?
No,
There are so many respondents. Huh? Social Welfare Department. You are for
social welfare.
Is down. Dealing by the social justice department.
Social Justice.
Yes, ma'am.
So their affidavit will cover
Yes, yes.
the issue.
Yes, sir.
So, okay, then their affidavit is only required, not others.
Not much.
So they need
42, we have not filed any.
item
42.
43 also they have not filed. So in both the matters, let them file affidavit within a short span of time. Okay, okay, Mr. Dasgupta. Heard Mr. Dasgupta, learned senior counsel assisted by Miss B. Das, learned counsel for the petitioner, and Miss Daniel. Give your name for Social Justice Department. Miss So-and-so, learned counsel, submits that she requires some time to file her affidavit in opposition to the instant petition. Prayer is allowed. List this matter. When can you file? But file it, huh? This matter has been 23 matters.
23 matter on several occasions, the matter was adjourned.
So find it as a last chance.
Last chance is appeal better.
List this matter on 22nd of April. 22nd of April, by which date the learned counsel would file the affidavit without fail. Right?
22nd. No, let it be 23rd or 24th.
20. Okay, 24th Friday. 24th.
24th.
Without fail and file the affidavit. No, it's okay. Without. Yes, Mr. Patwari.
Yes, madam.
Petitioner side is not there.
It's my side is not there. Because there is,
Yes, so many advocates, DJ Holloway.
because there is separation. Pointed out to the Honorable Court on the last occasion thereafter.
Acha, what? Why?
Well, what happened, advertisement was issued for appointment of staff nurse and critical care. And the private respondent will.
But he was there. The last time I don't think so he was there. But S does. Right.
Yes.
Respond number 4, J.I. Bodmi also is there.
Well, we remain there.
So it's okay. None appears for the petitioner on 4. List this matter again or?
After being the person.
If he has some urgency then.
Well, let you, I leave it to you.
On the 8th of April. 8th of April.
Yes.
If he doesn't come, then we will
Yes.
dismiss it or whatever for non-prosecution. Mr. J. Patrai, responding. You're for respondent number 346.
Yes, 3, 5, and 6.
And
Respondent number 4 and 7.
Miss
H. Debbie.
H. Devi for respondent number 4 and 7. And Mr. D. Permanu for health. For health department. No?
Deeply of them.
Thank you. Years.
Yes. Also, this matter pertains to transfer and posting. The respondents are not there. There are two cases, petitions. Actually, both are husband and wife. It's a spouse posting case. So that's why initially we have challenged 2 orders in one case. That's why a second we were the Honorable Court Director to file a separate case. So that's why the second. So your lordship can take up writ petition number 6914 of 24. Right?
What about respondents?
The pleadings are complete, lordship.
Pleadings are complete.
Yes.
They are not there.
Yes, lordship.
Who was supposed to be there?
Lordship,
Union of India.
Union of India.
Yes, I'm there.
SP Chaudhary, you are there. For?
Yes, for this first item.
Okay.
The issue is almost same here.
Same.
So this, since the pleadings have already been exchanged, the
Yes.
question is intent to take up the matter today itself. It's a matter of transfer. And these things.
Transfer. We can take it up. If
Yes,
the pleadings
I'm
are
ready.
complete. Right.
Yes, sir.
Oh, you are appearing for Mr. Chaudhary?
In item number, this one. 6914 loss. I'm appearing.
300?
6914. This is first one.
Okay, well, 300 is the first petition file or no?
No, no,
6914
6914 is the first.
6914 is the first.
Should I take it? What
691.
6914 loss.
69.
Yes, sir. 6914. Here you are appearing for all the respondents.
For all the respondents.
Also,
Acha, Union of India.
Union of India.
Union of India.
Road, okay. Directors of border road, everyone.
Everyone. Commander, assistant, administrative officer.
Okay. I'll take it.
Lordship, in this writ petition, we have challenged the transfer order. Actually, this case is pertains to spouse posting. So the posting of husband was made. Before I take the lordship to the documents, I just want to give a brief fact about the case. So we have placed a representation before the authority stating that we need to be transferred together because we have a child who is aged about 4 years. But while my representation was pending, the order of posting came. So thereafter, again, we submitted one more representation before the authority with the same ground that my child is of 4 years. We may be posted because the husband is posted in Jammu, and the wife is posted in Silapatha. And they have a child of 4 years. On that ground, again, we submitted a representation. They have not considered the same representation, second representation on the ground that 6 months advance representation have to be submitted. Thereafter, again, we submitted a third representation stating that we were not aware about this provision. And I also from record did not find any specific ground that 6 months advance notice have to be given.
6 months advance notice means?
That
6
for spouse posting, you have to inform the authorities 6 months in before,
6 months before from which day?
from the date of issuance of order.
How do we know order will be issued?
That is the thing. That's why I did not find anything. on record also. In fact, what I found was after receipt of the order of posting 45 days from thereafter, you can inform the authorities.
Acha,
I will
after
take
the order.
after the order. That is correct.
Okay.
Lordship. So my third representation was rejected. That they are stating that transfer and posting, you don't have any particular right. On that ground, they rejected my application. No way they have stated in all the three dismissal of my representation, no way they stated that there is no vacancies available. In this writ petition, after filing of this writ petition, the new ground which has come before this court is there is no vacancies available. That's why we cannot post you. You have to go to Jammu, she have to stay in Silapatha. That aspect also I placed before this honorable court because I bought with my additional affidavit. Subsequent my posting order, there were multiple transfers to these places. So that ground also does.
To which place they had represented it to be transferred?
A husband was posted in Jammu and Kashmir.
Oh, it's okay. Where, I mean, in representation, what did they write? They want themselves to be transferred
Anywhere,
to what place?
anywhere.
But
Together.
at one place.
Yes, together.
Together.
Because husband and 4-year-old kid is there. There are office memorandum also, which states that till the age of 18 years of the kid, of the child, they can be posted together.
There's a memo.
Yes, memorandum of understanding. Memorandum is also there. So now I'll take your lordship to the first order of transfer, which is page number 27. This was just a brief of the case.
They were working as what?
The husband is working as OEM, operator excavating machine. That's who takes up the suppose he's transferred to Jammu, so he's machine operator basically. It's one machine.
So it's connected with army, Shalmi?
Yeah, border roads.
A border.
Border roads.
Yes.
Border roads, the construction, the removal of roads, and suppose there's snow, so the machine used to remove snow and all. So that's the basically operation leader.
The wife is working.
Wife is she's a pioneer. That's a group D post where basically a desk job.
Under the border roads.
Yeah, both are under the same roof. Not a difference. So the posting order of the husband is annexure number 1, page number 27.
Where is it?
It's page number 27, annexure 1, relevant portion, page 32. My posting order. I'll take a look to the date of the order, 17/8/2024.
Wait, where is it? Where is it?
Page number 27.
No, 32 you said relevant.
Relevant portion is 32. Uday Pratap Singh, second number.
Same.
Yes, second number. He is a OEM. What you have seen, OEM, Uday Pratap Singh. He is posted from EBDW to Jammu Tawi.
Tawi.
Yes. They are currently posted in Sonitpur, Tezpur. They are currently posted in Tezpur.
Where do I find this?
Posting. That is not disputed also. They are currently in Tezpur.
So he is transferred to
Jammu Tawi.
Jammu Tawi.
Yes.
Yeah, in the year?
On 2024. First page number 27.
17/8/24.
17/8/2024. Thereafter, the second order of the wife.
Then?
The annexure number 2 is the order of the posting of the wife.
Page?
Page number 35. 28/8/2024.
35, yes. This is 28/8/2024, same year.
Same year.
Okay.
Yes.
It is-
Page number 40, relevant portion.
Chandravati.
Chandravati Srivastava.
She is transferred to Silapatha.
Silapatha.
Earlier she was where?
Both are in same place right now. In Tezpur.
In Tejpur.
Yeah, they are still
Before
together.
that, they were both in Tejpur.
Yeah, they are together in Tezpur.
Before this transfer.
Yes, before this transfer. At present, they are because there is a stay of this honorable court. So they are presently stationed in Tezpur.
They are posted from two.
Yes.
From two. So, EBW,
Eastern based workshop.
Eastern Based Workshop.
Yes.
See the chart
Yes.
posted from two. NRS is what? See the chart at page number 27.
27.
Posted from and to.
Yes, these are the posting the units names
Huh.
because they have a coded
Posted from EBW
to.
Beacon,
Yes, that's a place in that particular place only. Lordship.
Jammu.
Jammu itself. It is called Beacon. Beacon is the company name.
Acha.
Yes.
Which
That
is
what-
there in Jammu.
Jammu. That's why the
And what is this NRS?
it's the location. Lordship.
Huh?
Location, the area.
NRS stands for?
I have to take. Then my friend can say. Is that better?
Mr. Chaudhary, any idea?
These are all abbreviated terms. I will get the information. What is that?
So the fact remains he's from transferred from Tejpur to
Jammu.
Jammu, and she is also from Tejpur to Silapur.
Silapur. That's it.
Now there is a stay, so they are in Tejpur.
Yeah, it is.
Then
I'll take your lordship to the first representation which they have submitted. It is on 3/8/2024, page number 43, annexure 3.
spouse posting.
Yes, this is a request for spouse posting. This was before the issuance of the order of transfer, 3/8/2024.
Before issuance.
Before issuance of the order. First representation was this.
This was dated when? 3/8.
3/8.
3/8/24.
Yes. And
So they were aware that they will be transferred. So they had made the representation before order.
yeah, because the term period gets over, no, lordship. That's how they come to know. It might come like in a few months or something. So that's how they.
So that is why I think 6 months thing is.
But there is no. That's what I have placed before this honorable because I was not able to find where a 6 month period is there because they have submitted some documents with regards to the ROI of the organization. In there, no, I will show you, my lord, that there is no specific 6 months transfer. I was not able to find it. That's the only place.
Then?
The first ground 43 is the first representation which was submitted to them, which was duly received by the authorities. In this, she has stated clearly that me and my husband both are working in the same department, and I have a 3-year-old child. We both are posted in different unit. I face many problems in taking care of the child. Therefore, I request you to post us in one place, same unit, so that my younger child can be brought up in a proper manner. That is a genuine prayer. Thereafter, it was next page. It was sent to the subsequent authorities. The subsequent communication by the authorities. Now the rejection order is page number 46. The type copy. May I read what you? First ground of rejection.
OEM is not there.
Yes. In the place. On going through the case, observe that OEM post is not authorized in some selective choice station. Therefore, the application dated 3 submitted by the so-and-so Chandravati on spouse posting is returned herewith for resubmission, duly rectified observation, please. So they said, actually, in my first representation, she has given 5 place posting choice, which is also as per the norms, the ROI, I will place it. That for women, they can give 5 place choice posting. They have to, before their posting, they have to give a choice of 5 places. Okay. As such, she gave 5 places. So it was rejected.
She is not OEM.
So she can give for her. She is a pioneer.
Okay.
But in these 5 places, they say there is not a place for OEM. That means the husband is an OEM. So that's why it got rejected. They say you submit a fresh on that ground. Thereafter, it was conveyed to the respondent, and she have submitted second representation, which my lord will file at page number 50.
Yes.
This is the second representation. This is dated 31 August 2024, after the posting orders were out. So here also she has stated clearly.
After the posting orders.
Yes, because after the posting orders out, she have to send. Because
58/8/2024 posting orders.
yes.
And this representation was?
This April 31 August, 31/8/2024. Soon thereafter. Sir, it is because the authorities themselves in my first representative rejected that you file a fresh. Most respectfully, it will be in connection with my application dated 3rd August, so and so copy enclosed. I would like to submit the following few lines for your kind consideration. Sir, as it was earlier submitted, right? My application dated so and so, both are presently posted in so and so. Now means the course both of us has received posting orders in different station mentioned below. Sir, I would like to brief fact in the consideration. Being 3-year child, proper care is required pertaining to his health issues, education, and day-to-day family commitments. Being family dispute and the presence of my husband is essentially required to tackle the legal issues as stated earlier. Sir, through my consent, this is a basic genuine thing that she have a child and some family disputes are going on. So I need to be posted with my husband. So this was duly recommended by the authorities also. Page number 53, annexure is. In fact, Deputy Director General also recommended to the authorities, yes, they should be posted together. In this page, it can be very well said. It was recommended by Administrative Manager, Office Commandant, and Deputy Director General. Thereafter, Lordship, my second representation was rejected. Type copy I have placed, and the main copy is 56 page number. Type copy is 55. They state, please refer to your headquarter letter so and so. It is intimated that application submitted by Pioneer Chandravati of EWB of spouse posting received on 26 September so and so. Posting order have issued before the receipt of in the application. It is also intimated the application for spouse posting is to be submitted well in advance before completion of the tenure. The application of dated 3 August 2024 stated in the application has not been received by this office. In view thereof, it is requested to carry out the move as per the report. So here the ground they state that 6 months advance you have to send before your tenure gets completed. So that the only ground which is taken, no ground for with regards to vacancies or any other ground is stated. Since no application was submitted before 6 months, the application is rejected for spouse posting. Thereafter, again, one more representation was submitted. Same thing was conveyed to us by the subsequent communications, that is annexure 11. Thereafter, again, the representation was submitted, which is at annexure 12, page 59. Here, again, the same ground which have been stated. Relevant paragraph is the second paragraph. I, myself, and my husband are not aware about the rules for submitting applications 6 months in advance for spouse posting. Moreover, we thought that the record office has detail of me and my husband, hence the posting will be issued together based on the rules contained in the ROI as well as the government policies of the spouse posting. However, I have submitted an application on 3rd August with the choice station of so and so. All my choice station except Chandigarh have vacancy of OEM over so and so. Returned my application by letter dated so and so with the observation that OEM is not authorized in the selected choice. In the meantime, posting order have been issued and have based on the posting order, I have been compelled to request the change of posting while my application dated 31 August 2024. But simply rejected my request by the record on the plea the request received on 26 September 2024 after issuance of posting order. I have lot of mental stress due to which reasons the support of my husband, I could manage and perform my day-to-day duties, my brother. And so some family problem with regard to child. Our child is of 3 years age. Then beside the above. So thereafter, again, page number 62, they have again rejected.
What ground?
Annexure, the ground which is taken that is at page para 3. In this regard, your kind attention is also drawn to para 2 of chapter 24 of the ROI 19, where it is clearly endorsed that indication of choice station will not confer a right on the individual for posting to a choice station. Basically, the authorities are saying you cannot have a choice station with regards to posting. So on that ground, we accept it. You can post both of us anywhere. But at least post us together till our child attains the age of certain majority, so that at least husband and wife can be separated together. But that with regards to vacancies and anything, no grounds have been stated there. So thereafter, subsequent are thereafter, Lordship, they have provided in this petition the birth certificate of the child and everything. So I'll like to take your Lordship to page number 68 of the office memorandum. This is office memorandum dated 30 September 2009. with regards to posting of husband and wife at the same station issued by the Government of India, Ministry of Personal Public Grievance and Pension. May I read what? Yes. In view of utmost importance attached to the enhancement of the women's status in all walks of life and to enable them to lead a normal family life, as to ensure the education and welfare of children, guidelines were issued by DOPT OAM so and so, dated so and so, for posting of husband and wife who are in government service at the same station. Department has had on 2024 issued instruction to all ministry and department to follow the above guidelines in letter and spirit.
Memorandum that
Yes.
should be placed together.
Yes, the one more paragraph I would just like to take. This is the memorandum, page number 17.
70.
70, page number 70, point number 8. The husband and wife, may I read?
6.
8, Lordship, down.
Actually, husband and wife.
Yes,
Yes.
the husband and wife, if working in the same department and if required, level of post is available, should invariably be posted together in order to enable them to lead a normal family life, look after the welfare of the children, especially till the children attains 18 age. This will not apply to appointment under central staffing scheme where only wife is a government servant.
Level of post is available.
Yes, Lordship.
Should invariably.
Yes, but in their rejection order, nowhere I have placed it. They have nowhere stated that their post not available. Primarily, they have not stated anywhere. Now, the second MOA, which is the latest one, 24th November 2022.
Which?
Page number 72, the very next page. Posting of husband and wife, the below. The paragraph number 2. In the context of need to make concentrate effort to increase representation of women in central government jobs, these guidelines were reviewed to see whether instruction could be made mandatory, as it was decided when both spouses in same central service of working in same department, if posts are available, they may mandatorily be posted at the same station.
Invariably, now mandatory.
But
Yes.
it has been made mandatorily for a reason. Lordship. Why? Because, Lordship, the primary difficulty faced by a wife.
Yes, this is to bring up the children.
Yes.
to the home.
Lordship.
So it should be mandatory.
Yes, Lordship.
Provided posts are available.
Yes, Lordship.
Hmm.
But nowhere in their
Yes, they have said.
yes. Now I take a Lordship to their affidavit, which they have filed. In their affidavit, the first thing which they have stated is page number 79. Page number 79. They are stating that paragraph number 5, that there is a force deficiency of 472, that is 25% for OEM post. There is a force deficiency of pioneer post. Paragraph number 5. In view of the context, may I read it? Submitted that regarding trades of both the petitioner, this organization is authorized 1852 operator OEM, that is operator excavator machinery, and presently there are 1380 held with force deficiency of 472, that is 25%, and 7712 pioneer at present 5682 are authorized. So on 5682 are presently held. Out of 7712, there are only 5682 pioneers. There is a force deficiency of 26.35. When they themselves are saying
There is a deficiency.
deficiency, is how they can say there is no post now? When they themselves admitted that there are deficiency, they are this means
Both the post, OEM.
both the posts they are stating.
Fine.
They are vacancies. That means there are obviously there are vacancies.
But at what place?
That's what they have. Now, second thing which they have placed is
Because there has to be a place where OEM and pioneers are both
there.
required.
That now, what as per my instruction, the information which they have provided before this protocol. Suppose I am posted to the place. They have not provided any information because I can be posted in particular unit. there are multiple platoons or subunits there. There are vacancies in multiple nearby. Even if you don't consider the in the same unit, there are multiple platoons, there are vacancies. Plus, even if we don't consider the platoons, there are nearby units, which is at distance of 50 kilometers, 100 kilometers, there are vacancies available in there. That also information not provided before this honorable. The only information which is provided is that in that particular unit, in that particular platoon where I have been posted, there is no vacancy. That is the only thing which has been placed before this honorable court. Now I will like to take my lord to page number 88, page number 100. This is annexed by them. This is some amendment which was brought in the ROI on 24th April 2024.
So case to case basis.
Yes. Here also I was not able to find the 6 months which they have stated. But for point number 9, which I will just like to read. If vacancy in the post carrying both husband and wife is not available in the same station, their posting will be considered in the unit located near to the station. So, in fact, in their own ROI, it is stated that in the nearby station, if there is any vacancy, you please consider it. It is not. Station where other spouse is posted subject to availability of vacancy and also meet the operational and administrative requirement. Okay.
It is nearby.
At least nearby. Okay. Now, with regards to the yes. With regards to that, I have given 5 places of posting which they have rejected. 110 page number. Posting of female GRF employees. A 24A. May I read also? Female employees will be asked 5 choice stations in 3 different projects, and effort will be made to post them to one of the choice station. Present system of staying in one station for a very long duration will be discouraged. So basically 5 choice. That's why she have given 5 choices. Secondly, E. Turnover posting of female GRF employee will be done in the same manner as being done otherwise. However, efforts will be made to the extent possible to post husband and wife in the same station unit formation. Station unit formation. If both of them are GRF employees, which we both are GRF employees, subject to the requirement and constraint of the organization which they will have to override. Now, with regards to the second issue, that 6 months we have to take, page number 112. 30. Representation of posting issued, if any, from the unit as well as from individual will be initiated 30 days from the receipt of the posting order in the unit. Representation against posting order will be addressed over to OIC record of the project so and so, duly endorsed by the recommendation body of the representation itself. It will be ensured that such representation reaches GRF record within 45 days of receipt of posting order in the unit. That means within the period of 45 days of the posting order, you can submit a representation for change. But it was shown otherwise, which I leave it to my learned friend if they can show 6 months, but I was not able to find it. That's why what I could find is this. This is the thing which is stated there, that within 45 days from the receipt of order, you place a representation before the document. And the last portion in my reply to their affidavit, I would just like to show that subsequent to my posting orders, they have also made again posted. They have been stating there is no vacancy, but subsequent my posting orders, people have been posted there. Page number 148 of my. Yes. Page number 148, annexure 9 of my reply. The first person itself, he is posted to Jammu and Tawi from my place, same BRT. Again, this page number 152, Lordship. E. Mukteshwar Singh. Again, he was from Deccan. He was again posted to Jammu Tawi. He is also a pioneer, MSW pioneer. Lordship will see. Again, Lordship.
Where do I find pioneer?
Lordship, MSW PNR, the first above the name. Lordship,
Pioneer post are there in Jammu Tawi.
yes, Lordship. That's what I.
Could have been a-
Yes, I could have been. So these are all subsequent orders which I have placed on record.
So what do you say, Mr. Chaudhary?
No, with regard to the contention that has been raised, we have clarified the entire aspect in our affidavit, stating that since the petitioner, in both the petitioners, their case was initially considered. This is the second round they are paying for the place of posting in the same region. With regard to that, if you lordship kindly see the contention that has been taken by the respondent in our affidavit.
Oh, you have
If you-
learned few points that
Yes, lordship,
she had given her choice of posting.
exactly,
That was also rejected.
yes.
Then rejection was not only grounds of non-existence of vacancies, but they said that you should have paid 6 months prior. 6 months prior is nowhere in the memorandum. 45 days after the posting orders are issued. You can show. And there was one more point which was there in the representation, rejection order.
Choice person. They doesn't have a right for choice.
They don't have the right to choice.
It is already there in the rules that we have annexed in our affidavit, yes.
Spouse posting at one place.
Yes.
Apply to that.
So
When there are vacancies, when people are being appointed, transfer.
But that aspect of the matter, I will give a response with regard to that. But apart from that, the affidavit, what we have projected, if you lordship kindly see, starting from this paragraph number 13. Paragraph number 13, we have made a specifics. Categorical explanation to the contention of the writ petitioner.
Which page?
Page number 88, lordship.
But obligatory, it was obligatory.
May post the spouse to the same station, and the clause may represents the meaning of possibility and not obligatory.
But in the subsequent notification, it's
Yes,
mandatory.
and thereafter it has been mentioned, if I'll just take a lordship to this particular, guidelines. That it is very pertinent to mention here that in the organization as per para 2D8 and 10 of the headquarter DGBR posting policy, no subsequent back-to-back spouse posting will be applicable. So here in this case, the petitioner is already, presently they are enjoying this spouse posting, but they have applied for the second term for the same spouse posting. So we have taken a plea that back-to-back spouse posting is not applicable so far as the petitioners are concerned.
Back to back, why? The child is small.
Lordship kindly see.
Where is the bar?
Yes, I'm saying that, Lordship. Lordship kindly see this particular, page number 99. Para 2B, 8 and 10. Yes, these are really, this page number 100. Spouse posting.
2B.
2B, Lordship. This is with regard to the spouse posting. This, we're just referring to this, the subclause 8. If both husband and wife are grave employee, they will be posted in the same station, either in SA, MA or HA, as per service profile, subject to availability of family accommodation and educational facilities. However, choice can be considered only on the grounds of higher education of children. If both are due for HA, then they may be considered for HA units on the willingness of the couple. When husband is due for HA, he will be considered alone for posting.
Which is HAA.
High altitude lodging area. High altitude area. So here in this case, it has been mentioned that however, choice can be considered only on the ground of higher education of children. If both are due for HAA, they may be considered for HA units on the willingness of the couple. When husband is due for HA, he will be considered alone for posting in HA.
And wife
Wife may be considered in any station near to HA. So here in this case, lordship, this husband has been considered for HA units having a classification.
they should have posted nearby.
Exactly. So here in this case, subsequent to that, lordship kindly see the subclause 10.
Considering the service condition, transfer liability of GRAF in comparison to other central government departments, couples will also be liable to serve separately due to exigencies of service, and no one can claim spouse posting as a right.
Yeah, that
So
is there.
this particular provision is there. So if there has been made in this particular repetition or this representation that has been there. So this provision, this page number 100 and subclause 10 is very specific. It's not a right. So here in this case, these petitioners have to come up with a plea that there is some arbitrariness on the part of the authorities. Since the right is not there, they cannot claim it. So what has happened to the petitioner and whatever order has been passed in the
But
representation?
the first clause
Yes.
may be considered case.
Need to consider, but it is not obligatory. We are saying that it is not obligatory. Considering that they are already, presently they are enjoying the spouse posting. The second spouse posting with regard to the petitioners has not been taken into consideration. So the HAA, this higher altitude area, has been taken for the husband. So he has been posted to a separate place of posting. And since the right is not there, so this the arbitrariness in absence of
Right
any.
is not there.
Yes.
It has to be considered.
Exactly,
But the
Lordship.
fact remains is that she has a small child and there are some family disputes also. So if he is at HAA area, then the wife should be accommodated somewhere nearby, not Chilapathar and Jammu,
No.
hundreds and thousands kilometers away.
Exactly, Lordship. But the fact is that, Lordship, this petition has been filed saying that they are praying for the spouse posting. Now, with regard to this spouse posting, they have to show that they are having substantial right to claim that first spouse posting, because presently they are enjoying that. Since they are enjoying now, so we are saying that the second spouse posting is not applicable so far as the petition
Where
is
is the
concerned.
word anywhere it is said?
No,
So back-
since there is no obligatory, it's not obligatory on the
No,
part
it
of
is
the
mandatory
respondent.
later on by amendment.
No, Lordship.
Acha, well, you have something more to say because I have an appointment at 1:30.
Then, Lordship, in the second half,
Second half.
or on any other date.
2:30, no, today.
No, today
only.
only.
Today heard
Yes, no. Then at 2:30, 2:30.
38.
Lordship.
Something to say? What you put you like? The learning council. Oh, no. P9, learned council, so P9. So from here, I forget the names, otherwise I call you by first name. And the standing council for James, submits that the petitioner side is also not present, and he also has to file his affidavit.
Affidavit is already filed with my lordship. It's a matter of payment of area pension lordship.
So he's also there, he's there, you're for the petitioner.
Not he is not the
That's it.
Not in concerned person who retired in the year 1996 and the person died in 2008.
Okay,
Now-
we'll take it up some other day. As prayed for by Mr. Swans, I, council for GMC, submits that the matter will be taken up on a later date. Fair is allowed. List this matter on after the
Vacation after vacation.
list this matter on 24th of April.
Next.
Respondent number 3. Okay, I'll come back at 2:30.
Next, lordship.
Come back at 2:30. I'll have to go.
Lordship, actually, it will be adjournment, lordship. The petition, learned counsel for the petitioner of item number 56, he informed our telephone me that he could not come today due to medical issue. lordship.
As prayed for
Said-
learned council.
Fix and another.
Let's list this matter on 27th of April.
Lordship, applies.
Follow this matter, I think it will take some time. Supplementary admission. So my learned friend appears for the petitioner. I appear for the private college authority. But affidavit from the government is not there. So because whether my friend will file an affidavit or not.
This case, because main thing, the particular, although college is provincialized, but particular department is
Self-finance.
self-finance.
Self?
Self-finance.
Self-finance.
And as such, the dispute between the college authority and the petitioner, such, higher, at present, higher, not such role.
Higher secondary education.
Higher education.
Higher education.
Education not required to file affidavit.
At present, lordship. If
Tussle is between finance.
the college authority and the petitioner.
Oh,
The department is the, not provincial.
not provincial.
Not provincial.
Acha, a college can be provincialized, like leaving aside the department.
Yes.
Yes.
It
Yes,
can be.
yes, as per new amendment, my lord, the college definition will be changed. Even a provincialized college may have the venture department.
Oh, I didn't know.
So let it come up some other day because I think this matter will take some time.
It will take some time. And Miss Saikia,
friend
Mrs. Saikia is also sitting for some matter? For disposal or?
Is next item because 53, my lord, because as the time being items are all done. So I am stuck here.
Oh, 53.
Yes, my,
Acha, 53, okay. This is for orders otherwise.
yes, my lord, because your lordship has completed the hearing that day, my lord, on Monday, your lordship wanted to pass the order.
Huh.
But on, I don't know her name, she took time for taking instruction.
Okay, okay. Otherwise matter
That leave.
can be disposed of.
Yes, ma'am. Matter in,
Okay, immediately after this, I'll take yours.
yes, ma'am.
You can go and have, come after some time because
No,
I'll
my lord,
dictate the
another
order.
court, I am waiting another court here after my lord, that will reach me.
Because I will dictate this order of Mr.
Yes.
That will
I
take
have
some
to
time.
wait here because my lord, that will also take time. Yeah,
Oh.
court number 22.
I could have taken your matter before this one. I didn't notice.
Yes, ma'am.
Okay, I'll see her. As soon as possible, I'll take it up.
Yes.
Okay, Mr. Aniba, so your matter, I'll post it some other day.
Some other day, my lord.
Okay, Mr. A. Das, learned counsel for respondent number 3 to 6, right?
Yes, see.
3 to 6 makes a prayer and the matter may be taken up on a later date. Prayer is allowed. List this matter when?
The first week of May, my lord.
First week of May.
Yes.
List this matter on 7th of May. Okay.
Let it be on a joint prayer.
Okay.
Because he is also there.
I cannot, my lord, my name may not be recorded for.
Okay, let it be.
They are prayer, my lord.
Don't worry.
They are they are prayer.
Okay.
Oblige, my lord.
Yes.
Sorry to bother your lordship's address and that's all. Item number 49, the epidemic is on file. The matters are going on, my lord, hearing is going on. Another court, the hearing was going on. I could not come present to the court, my lord. In fact, the hearing is continuing there, my lord. So my issues are same, my lord. My friend is there, my lord, Mr. S.P. Chaudhary. So I am also there in item number 49, my lord.
Otherwise, what am I taking? 49?
So,
50.
50, my lord. Both
Same,
it is the
husband
same.
and wife.
Husband and wife.
Spouse posting.
Yes, pass.
Oh, that is
This 50, the
so
item
you
number
got
50.
59.
Yes.
Hearing 50.
In item number 50,
50 suffice.
Perfect, my lord. That is why I'm, my lord.
the
Hello.
issue which is there in the item number 50 should cover.
Same.
It's okay. I'll record your name.
My lord.
During this case, lordship,
So what you are saying is that
Yes.
repeated spouse posting
Yes,
is
sir.
not provided.
if your lordship kindly see the affidavit, the points that you have raised in our affidavit, lordship kindly see page number 80.
80.
80. Here in this case, the classification has been mentioned in paragraph number 6. This GRAB BRO is set up for carrying out construction of infrastructure for nation building, especially in remote border areas. Strengthen defense mechanism. Most of the works assigned to this organization are strategically important to Ministry of Defense. In order to execute this work, maximum units establishments are located at far-flung areas of our motherland, especially at high altitude, harsh and inhabitable climate, remote and far-flung locations. And these areas are classified into high altitude area, HAA, hard area, soft area, and most attractive area, and also classified at extreme coastal area and moderate coastal area, in short, MHA. Now, here in this case, lordship, the petitioner number 2 is the wife. The next paragraph, we have made a mention with regard to the fact that it served more than 14.75 years in western sector and only 6.67 years in eastern sector, and serving continuously in most attractive area of the soft area. So here in this case, this petitioner number 2 is discharging a service in.
Since 14.75 years.
Yes, lordship is 14 years, some months. So they have calculated it like that, 14.75 years. So 6.67 years in eastern sector and serving continuously in most attractive area, soft area since her appointment, July 2003. So she has substantially served in that particular area. So here in this case, the other person, the petitioner number 1, the Uday Pratap Singh, had only 6.5 years total service and continuously in soft area since August 2021. That is 3.5 years. Their posting orders have been issued in accordance with their balance service. So that has been done.
So many years of service and here so less.
Exactly, Lordship. So here in this case, this the balance service and the service sector profile as per chapter this 24, this order has been issued. Now, if you, Lordship, kindly go to the chapter 4 and with regard to this.
Chapter 24.
Yes, chapter 24.
Where do I find this?
Yes, I'm just going to that now. Chapter 24, it is at page number 102. Annexure R3. Lordship, kindly see the service profile. It is a profile. It is at page number 106, paragraph number 10. There it is 10A. The service profile is subject to organizational requirement. It expect to be as under. So here in this case, Lordship, this service profile means length of tenure, number of tenure, and total service. So it has been specified here. A person who is in soft area, then this one, most attractive area, this MAA, it's most attractive area. So all these things have been specified. Total service 6 years, 4 years, 6, and all this total service. So here in this case, Lordship, the two petitioners, the transfer order that has been issued in view of taking into account the service profile of these two petitioners, because one has petitioner number 1, he has discharged a service in a particular area for a long period of time. We have specified it in our affidavit also. One is 14.75 years. And the other person had only petitioner number 2. And the petitioner number 1, Uday Pratap Chik, had only 6.5 years total service and continuously in soft area since August 2021. And that is the reason why, Lordship, he has been transferred to the new place of posting. This is an extreme coastal area. This is not high altitude area. This is the extreme coastal area. Why I am saying this extreme coastal area, Lordship? This is because of the fact that coastal area. This is at EHA.
Oh, yes.
The second one. The first one is high altitude area. The second one is extreme coastal area. Now this page number 100.
106.
100. This annexure R12. This is this spouse posting at the subclause 8 of clause B. Here in this case, it is mentioned if both the husband and wife are grave employees, they will be posted in the same station, either in SA or MAA, most attractive area, as per the service profile, subject to availability of
HA, EHA, SHA, or
these are all this high altitude area, then this extreme extreme hostel area. So these are all like that, as per service profile, subject to availability of family accommodation and educational facilities. However, choice can be considered only on the ground of higher education of children. This is only with regard to the higher education of children. Now, if both are due for HAA, that means high altitude, a high altitude area, they may be considered for HAA units on the willingness of the couple. When husband is due, here in this case, Lordship, when the husband is due for HAA, he will be considered alone for posting in high altitude area. Wife may be considered to any station near HAA units having a classification other than HAA. So this particular thing with regard to the posting to a near station is applicable only when it's a case of HAA. That means high altitude area. Here in this case, the petitioner number 1, he has been posted to the present place of this, the subsequent place of posting. It's HEA. This is this if your Lordship kindly see, it is in page number 80. It has been specified. HEA
page number?
Page number 80.
So this Silapathar is what area?
Silapathar is the soft area.
Soft area.
Soft area. So
And Jammu, this one is a hard.
extreme EHA. This is the extreme coastal area. It is there in page number 106.
It's both EHA and HHA. It is not only EHA.
It is high
EHA
altitude area also.
Yeah, it's a high altitude area.
No.
Plus, and it's a hostile area because it's a because because of the border region. That's the only hostility.
So the extreme coastal area, this is it is there in page number 106. Now here in this case, Lordship, subsequent to that, no subsequent back-to-back spouse posting will be applicable.
Where?
In that particular paragraph number, page number 100, this clause number 8, it is mentioned that other than HA, the no subsequent back-to-back spouse posting will be applicable. So it has been specified herein that no subsequent back-to-back spouse posting will be applicable.
This is in context with the said paragraph, no?
Yes.
Should be considered alone,
Exactly.
why could be considered
Ah,
to any station near
Ah.
HAA, having a classification other than HAA. No subsequent back-to-back spouse posting will be applicable.
now we are relying on this paragraph number 10 also, Lordship. Considering the serving condition and transfer liability of grave in comparison to other central government department, couples will also be liable to serve separately due to exigencies of service, and no one can claim spouse posting as a right. So here,
Okay, that's
yes.
shown, but what is your answer to this no back-to-back spouse posting?
Lordship, with regards to this,
They were both in Tejpur.
the child was born in 2020. They were posted in Tezpur 2021. This amendment, which my friend is relying, came in the year 2024,
And your transfer was done where?
25. you see. No, that point of time, I was transferred to Tezpur 21 when as per them that I have taken a spouse posting. That time this amendment was not even there. Subsequently, my friend, which he is reading with regards to HHA, I am not asking them, you post me in this particular area or that particular area. The only contention at present, before this honorable court is that you can post us together in any area you want. If you want to post both of us together to the high altitude area, you can post us. If you want to post her to soft area, you can post her. But at least my child is 4 years old. Right? If suppose if they are not posted together, one has to either, because your lordship is well aware, one person will have to leave the job to take care of the child. So, and moreover, if they both are placed together, it is beneficiary for the organization itself. Their leave will be less. Now, one contention also raised before this in their affidavit that with regards to vacancy, they have stated
That
that
you said, and later.
no, they
For my transfer.
no, one thing which they have stated is that page number 84, that she can take CCL, childcare leave, for 730 days. Yes. Not if their service condition, they will be posted separately. If the person takes 730 days childcare leave, child is 4 years old, how many days will be left? And secondly, if she take leaves also, it's bad for the organization itself. It is if a person takes a leave in case of exigencies. So this and the ground which is taken by them is that no back-to-back spouse posting can be taken. I have with me, I was instructed, I also asked them. I was told they have cases where back-to-back spouse posting had been done, and I have bought that also on record.
No, if they have done something wrong with others, that will not.
I'm not saying, but at least some humanitarian grounds should be taken into consideration, Lordship. In the rejection, they have never stated about back-to-back posting. The only ground they have stated that you have not placed in 6 months, you have not, it doesn't give you a right. Thereafter, they come and say there is no vacancy. Now, when I've stated there were vacancy and subsequent transfer, they cannot do back-to-back spouse posting. So at all the instances, their reply is keep on changing.
Okay.
There is no concrete one.
This is all.
Yeah, that's all from my end.
Okay, Mr. SP Chaudhary.
Lordship, here
Consider for.
Lordship, here in this case, I am just relying on certain judgment of this Honorable Apex Court. Can you finish these 2 judgments?
I'll mention it in the order.
Yes, sir.
Heard, Mr.
F for Faridi.
A. Faridi.
F
Faridi, learned counsel for the petition, and Mr. S. Chaudhary, learned counsel for all the respondents. By this application filed under Article 226 of the Constitution of India, the petitioners have prayed for spouse posting at one particular place. কতটা নামটা দিন একটু কিছু
49. This is with regard to amendment 49.
But 49 order.
No, it can be clubbed
one
together,
order
Lord.
here,
One order can be chopped.
One order here,
Exactly.
Same.
as well as DDM, as well as Mr. কি নাম সেটা?
UK Goswami.
UK Goswami.
Yes.
SP Chaudhary as well as Mr. UK Goswami for all the response. By this application, they have praise for spouse posting in one particular area. First, the petitioners have also challenged the posting and transfer order dated 17/8/2024, by which petitioner number 1 was transferred to Jammu what?
Jammu Tawi,
Tawi.
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 Huh?
Tawi, TAWI.
TAWI. Oh, Tawi. And petitioner number 2 was transferred to Silapatha.
Shilabh.
It is the case of the petitioners, that both of them were working under the General Reserve Engineering Force. General Reserve Engineer Force. Full comma. Petitioner number 1 as OEM. What was that?
Operator excavating machinery.
Operator excavatory machinery.
Excavating machinery.
Excavating machinery.
Machinery.
And petitioner number 2
Spine.
was working as pioneer in the Eastern Base Workshop, EBW, GREF, Tejpur. Both the petitioners were working in the organization since 2018 and 2003, respectively. Under the set graph. The petitioner states that while they were working in their respective post at Tejpur, respondent number 4 issued an order for the posting and transfer of General Reserve Engineer Force personnel through posting order dated 17/8/2024. By which, as stated above, petitioner number 1 was transferred to Jammu Tawi and petitioner number 2 was transferred to Silapatha. The petitioner states that they have a small child of 4 years of age and agreed by the posting. The petitioner number 2, petitioner number 2 submitted a representation on 3/8/2024 stating inter alia that both the petitioners are employed in the same department and are parents to a 3-year-old child, and that posting at different places would create hardship in raising their child. Also, accordingly, petitioner number 2 requested the respondent authorities to consider granting spouse posting in the same unit at a same unit at a particular place. Petitioner number 2 had also apprised the authorities of an ongoing legal dispute with her brother regarding family property, which, according to her, has caused immense hardship and that posting at a different station from her husband would exaggerate exaggerate her problems, which would have an effect upon her ability to discharge her duties. Full stop. The said representation was forwarded by the administrative officer, estate and finance officer, on behalf of officiating commandant However, respondent number 9. However, respondent authorities, through a letter dated 2/9/2024, replied that the post of OEM, which petitioner number 1 was holding, was not present in some of the selected choice stations. It be stated here that the petitioner number 2, while giving her representation, had enumerated certain choice stations. 5 numbers, right?
Yes, 5 minutes.
5 numbers of certain, no, certain, no, 5 numbers of choice stations
As per the ROI, it's there.
as per the ROI.
ROI, record of this instance.
Full stop. The authorities apprised her that she may file another representation. Thereafter, the petitioner number 2 submitted a fresh representation on 31/8/2024. You want to go, sir?
Yes, Your Lordship. Whatever, Your Lordship.
Submitted a fresh representation on 31/8/2024 to the respondent authorities by referring to her earlier representation and she requested for spouse posting. Again, she had again reiterated the reasons of her child to be raised and her family disputes. Full stop. The said representation was again forwarded by the authorities concerned. But the respondent authorities informed that the posting orders were issued prior to the receipt of the representation by petitioner number 2. Full stop. It was intimated that petitioner has to submit 6 months before the completion of the tenure, has to submit the representation. 6 months before the completion of the tenure, as per the alleged guidelines. And as such, the representation given by the petitioner was not considered. Full stop. Thereafter, petitioner number 2 had given yet another representation on 28/10/2024. Stating inter alia that she was not aware of the 6 months advanced application and that she had given representations beforehand, which was rejected on one ground or the other. She as such requested the respondent authorities to either transfer to a place near her husband's posting or transfer her husband near her posting. Right. This application was also rejected by the respondent authorities. This representation was also rejected by the respondent authorities, saying that indication of choice of stations will not confer a right for posting. No. And that posting will be determined on the basis of availability of vacancies. Full stop. The petitioner number 2 was directed to proceed to the new place of posting. Mr. Faridi, learned counsel for the petitioner submits that the rejection of the representations on the grounds that giving choice posting is not a matter of right, or representation to be given 6 months before the tenure gets over, or non-availability of vacancies are not tenable in the facts and laws of this case. How did you start the sentence? Last sentence. Mr. Paridi. Okay, articles are not tenable in facts and eyes of law. He submits that by posting order dated 17/8/2024, petitioner number 1 was transferred from Tejpur to Jammu Tawi, and by order dated 28/8/2024, Petitioner number 2 was transferred from Tejpur to Silapatha. He submitted that various representations were given to the respondent authorities requesting spouse posting, and the same were rejected on the grounds as stated above. He placed reliance on the office memorandum dated 30th of September 2009, wherein it is stated that when spouses work in the same department and if posts are available, they may be mandatorily be posted at the same station. He has also relied on the office memorandum dated 24th November 2022, which states inter alia that for enhancing women's status in all walks of life, and in order to enable them to lead a normal family life, as also to ensure education and welfare of children, posting of husband and wife who are in government service should be at the same station. The said instructions were directed to be followed by all departments in letter and spirit. It was again reiterated in the said office memorandum that spouses working in the same department should be mandatorily posted at the same station, of course with the rider that if posts are available. Of course with the rider, provided that the posts are available.
Page number 74 till 18 years of age also is there.
74.
8.8.
Point?
Eight.
Oh, no, page what?
Page number 74.
74, no, 8.
Page number 7. Point.
The said memorandum also provides that the spouse posting should be at one place till the children attain 18 years of age. And what else did you point out?
I pointed out, Lordship, with regards to page number 110, with regards to female employee, the choices were given as per their own ROI.
110.
110.
He also has relied on the office memorandum, on this, no, he also has relied on the amendment made in the said office memorandum. Oh, no. He relied on chapter 24.
Yes, 24.
Chapter 24 of what?
24 of ROI, there on record office instruction.
He has also relied on the chapter 24 of ROI's instruction.
Record office instruction,
Record office instruction, no?
bracket ROI.
Bracket ROI. Wherein it is provided. Where?
110. Serial number 24A.
Provided that female employees would be asked 5 choice stations and efforts will be made to post it to one of the choice stations.
E also.
Furthermore, it is provided that efforts will also be made to the best extent possible to post husband and wife in the same station / unit formation if both the husband and wife are gref employees. However, subject to requirement and constraints of the organization.
Thereafter, page 112, 30, point number 30, at 45 days after posting order.
He as such submits that the petitioners should have been, no, he as such submits that in consonance with the said instructions, the petitioner number 2 had given 5 stations of her choice. But the respondent authorities have not given any hint. By saying that posts were not available, right? Oh, no.
No, 6 months. They should
No,
have given 6
months is okay. In that case, 5 choice postings, they said that
Some post of OEM.
OME
Yes, OEM is not available in few places. That's why.
is stating, Kikolo? Saying that the post of OME
OEM.
or OEM is not available in few of the stations. Learned Counsel has also relied on the instructions which provides that after the posting order, within 45 days, representations can be made. And he submits that nowhere in the instructions or in the memorandums, 6 months or the requirement of giving representations 6 months prior to the expiration of the tenure is provided for.
But they have also not stated anything.
To which the Learned Counsel for the respondents have also, to which the Learned Counsel for the respondents also could not place the said requirement.
Lastly, Lordship, under page number 100. 9. The amendment. Page number 100.
Yes.
Point number 9.
The Learned Counsel also submits that as per office amendments to the office memorandum dated 24th November 2022, it is provided that if the husband is posted to high altitude area or what? There was
No.
not
9, next.
high altitude area or
No, not that, Lordship.
not high
Relying-
altitude.
I'm not relying on that. I'm relying on point number 9, Lordship.
So
100.
provides that if the vacancy is not available for both the husband and wife to be accommodated in the same station, the wife or the husband should be accommodated in the nearby stations. As such, he submits. As such, he submits that the petitioner number 1 and 2 be accommodated at one station. And if it is not possible, then at least the husband or the wife may be accommodated in a nearby areas. And he also submits that the posting can be done anywhere in the country, but they should be posted together or the nearby areas as stated above. These are your submissions?
Yes.
Mr. S.P. Chaudhary, learned counsel for the respondents, submits that S.P. Chaudhary, learned counsel for the respondents, by relying on the affidavit filed by him, submits that the petitioner number 1 and 2 were posted in Tejpur before they were transferred by order dated by 2 orders, right?
Yes, 2 of them.
By order dated
17/8/24 and 28/24.
by orders dated 17/8/2024 as well as
28/8/24.
28/8/24.
Yes.
And that he submits that back-to-back spouse posting is not permissible under the rules. He submitted that petitioner number 1, he had shown some high.
Yes, page number 100.
From the pleadings, he showed something that so many years,
Yes, 80, page number
page number 80.
80. 14.75.
Huh.
Yes.
Yes. He submits that
Seven.
petitioner number 2 had served more than 14.75 years in Western sector and only 6.67 years in Eastern sector, and that she served in most attractive area / soft area since her appointment in July 2003. Whereas petitioner number 1 had only 6.5 years of total service in the soft area since August 2021. And that these posting orders were issued in accordance with their balance service. No, you write posting orders has been issued by balancing their service tenure. He relies on the amendment to the Office Memorandum dated 24th September, 24th November 22, in which it is stated that husband and wife, being ref employees, would be posted in the same station, either in soft area slash attractive area, Samna,
Most attractive area.
most attractive area, or high areas,
Hard area,
hard areas, slash
extremely hostile area.
extremely hostile area, slash high
This is hard
area, slash high altitude area,
areas.
as per service profile. And that choice of posting should be considered only on grounds of higher education of children. It is further provided that if both the husband and wife are due for high altitude area, they may be considered for high altitude area units. Of course, on willingness of the couple. It also provides that when the husband is due for high altitude area, the wife may be considered to any station near the high altitude area, and that no back-to-back spouse postings will be applicable. He has also pointed out that couples will be liable to serve separately in case of exigencies of service, and no one can claim spouse posting as a right. He has also submitted that specific period needs to be served by the employees working in the GREF in respect of various areas, that is HAA, EHA, HHA, HA, SA, MME. Accordingly, he submits that the posting ordered to both the petitioners is not illegal, and the petitioner should go and join the respective post at the respective places. I've heard the counsels and I've gone through the records. It is noticed that the spouse posting is provided for under the various memoranda and instructions. Provided for by the Government of India, Ministry of Personnel, Public Grievances and Pensions Department of Personnel and Training Establishment. Final. And it has been provided that the husband and wife should be posted as far as possible at the same station, so that there is enhancement of women's status, as well as the children should get proper education, and upbringing. The said policy has been followed in all the central services as well as directed to be followed in all the departments.
So I'm relying on two judgments with regard to this. as well.
Oh, yes, that I will got it.
With regard to the spouse transfer lawsuit, there's
Okay,
the
I will.
judgment on the textbook.
Actually, to tell it before that, you're right. To substantiate his argument, Mr. S.P. Chaudhary relies on two judgments,
Yes.
relies on two judgments passed by the Honorable Apex Court. Number one,
1993 OSCC
93 4 SCC,
357.
357, party's name.
Union of India versus SL Abbas.
Give me that
Yes.
by the Apex Court in Union of India. I've got a citation from Diba. In Union of India versus
SL Abbas lawsuit.
SL Abbas, reported in 94-3,
1993 4SCC.
93 4 SCC. Wherein the Apex Court had held, what paragraph?
In paragraph number 6 and 7 lawsuit. An order of transfer is an incident of government service. Fundamental Rule 11 says that the whole time of the government service at the disposal of the government, which pays in.
It's okay, this is a general.
Yes. No, with regard to this one, spouse also.
Oh.
is mentioned.
Wherein the Honorable Apex Court had held that order of transfer is an incident of government service and based its spouse thing.
This paragraph number 7, lordship, last 3 lines. The guidelines say that as far as possible, husband and wife must be posted at the same place. The said guidelines, however, does not confer upon the government employee legally
In
accept
that-
saying right.
Spouse posting is although provided for, but the same does not confer upon the employee a legal enforceable right. Number two,
And the 2004 7 SSC lordship.
Dashrath Singh versus State of UP,
Must-
reported in 2004, 7 SCC 408. Was it this? No.
No, 2004 7 SSC, state of UP versus Sitas.
Oh, no, no, no. Two, on the other page it is there,
Okay.
on the next page.
Yes, sir.
Yes, two dear. State of UP versus CRM and another. Reported in 2004, 7 SCC 405. Wherein the Apex Court had held, which paragraph?
Paragraph number 5, lordship. The High Court, while exercising jurisdiction under Article 226, that gone into the questions to whether the transfer was in the interest of public service. They do essentially require.
Wherein it was held that the particular employee cannot claim to stay at one particular place. And that transfer is a incident of, is a condition of service,
This is with regard to the Malafide lawsuit. There is no Malafide.
necessary in public interest and in the public administration. And unless the same is done with some malified
Malafide.
exercise,
Yes, sir.
it cannot be interfered with. Absolutely. People last of Christmas. It is noticed that although spouse posting is not a matter of right, but it has been held, it has been provided for in various memorandums and the instructions that as far as possible, the husband and wife should be stationed at one particular place, especially due to the fact that the children should have a proper upbringing. Petitioner number 2 had made representation a number of times. The first being, which was the first one?
First was, the first page number, topic 3.
The first being on 3/8/2024. That is before the transfer and posting of the petitioners, intimating the authorities that she has a 3-year-old child and that she would face problems in taking care of the child, and that she has family problems too, and prayed by way of the said representation that her husband may be posted at the same station as she was. And she had given 5 places of posting. That is Tejpur, Chandigarh, Gangtok, Udhampur, Pathankot. But the said representation was rejected. On the ground. Where is the rejection?
46 page. Page number 46.
On the ground that the post of OEM, which her husband is holding, is not authorized in some of the selected choice stations, which makes it clear that in some of the in few of the choice stations, the OEM post is available. It is not in respect of all the 5 stations, but in few of them it is available. As such, the rejection order is not proper. Thereafter, she made another application with the same prayer. Where is that?
Page number 15.
15. With the same prayer, but the said representation was again rejected
55.
on the ground that
Minimum 6 months.
that the application for spouse posting. Where is that? Somebody is seeing. Okay, what did I say? That the application for spouse posting has to be submitted 6 months before the completion of the tenure. The said reason for rejection is again not tenable, inasmuch as it is nowhere provided in the memorandum or in the instructions that the said requirement is needed. It is what is provided in the instruction is that within 45 days from the date of posting, representations can be made. Full stop. Thereafter, the petitioner has again requested for spouse posting.
Page number 59.
And the same was rejected. Where?
62.
Was rejected on the ground that giving of choice stations will not confer any right for posting. The said ground is also not tenable, since there is no dispute with that fact that it is not anybody's right, but it is provided that as far as possible, they should be posted together for reasons mentioned above. This is all.
Yes.
Therefore, it is seen that a rejection of the representations are not tenable in the eyes of law, nor in the facts of the case. It is also stated by the petitioner's counsel that posts are available in Jammu Tawi and employees are being transferred there. However, the same is rejected in case of the petitions. What I'll do is you make an application and that has to be considered in the light of whatever. In view of what has been stated above, this court directs the respondent authorities to properly consider the representation of the petitioner who would file the same before the authorities. The full stop. The authorities should consider the memorandum and the instructions that when husband and wife are grave employees, both of them should be posted in the same station. And if the husband is posted in hard areas or likewise, the wife, that is petitioner number 2, should be posted near the said place. Especially because of the underlying basic requirement given in the memorandum, that is to enhance the women's participation in employment as well as for taking care of the children. That is all.
Yes.
If something is required, I'll just add. Petition is as such disposed of with the above findings.
Also, the stay order is there now. This
Now,
stay order is-
the authorities to dispose of the representation within a reasonable time.
No, he has to submit a representation within stipulated.
Reasonable time from the date of submission of the representation.
No, can I fix a date because we will have to submit the representation
2
within
weeks.
a period of 2 weeks.
We will submit
And
4
within-
weeks subsequent, we can dispose of.
And within 4 weeks. the represent-
Nalage hetu to tell. What did I say? Nalage hetu. The authorities are further directed. Oh, no.
No, he has to submit the
Petitioner-
representation.
The petitioners are directed to submit the representation within a period of 2 weeks from the date of the order, and the respondent authorities to dispose of the said representation within a period of 2 weeks thereafter.
Yes. 4 weeks. The 2 weeks.
2 weeks, 2 weeks,
2 weeks.
2 weeks thereafter.
Yes.
Petition is disposed of, and then the stay order stands vacated.
Till disposal, no adverse steps.
Mhm.
Till disposal of my representation, they may be posted where they are.
No, it is there. No,
They have to come with.
No, since the order is there with regard to the set aside, the orders have been set aside. No, you have to transfer orders. You take care of it. The rejection orders have been interfered with.
Further, the orders has to be interpreted.
Yes, yes.
Further, the posting further the transfer and posting orders dated 17/8/2024 in respect of the petitioner number 1 and order dated 28/8, right? Order dated 28/8/2024 for the petitioner number 2 is interfered with. It is also directed. No, but then do one thing, like Supreme Court has said, go and join the post. And then it will
So this order is there. I'm just intending to rely on that because
Again, going back,
because-
again staying, at least because similar order also I got in other case. Till disposal of the representation, my representation, I may stay there, let them dispose of. And then at least we can have, because
Lordship,
again, going back, it's
this is a
again,
judgment of 2006, Lordship. The Honorable Apex Court has said the duty of the government service to comply with the transfer order, emphasize tendency of not reporting of the new place of posting, indulging in litigation, ventilate grievance and needs to be curbed.
Lordship,
That's what.
one aspect is there, if the transfer order has been set aside by this honorable court. So the posting order already gone, Lordship. They cannot be interfering, they cannot go again. That is why I have approached this honorable court.
In view of the fact that the petitioners have a 4-year-old child, this court directs that the petitioners would make the representation while staying in Tejpur, and the same may be considered as an exceptional case. And thereafter, orders of posting and transfer be issued. That will
Lordship,
suffice.
in this case, this petitioners, otherwise they are not having any issue with regard to going to this place of posting at this Jammu. The fact is that he is saying that he has to be given the petitioner number 2 is to be given some place near to that place, the place where the petition number has been posted. So instead of interfering with that, it should be kept on pending till disposal of the representation. Because if he is intending to go to Kashmir, because as per this transfer policy, he has to go to soft place to hard place. These things are there. So again, this will create some sort of confusion.
They will decide, Lordship. Representation I'll give.
Because
Let them decide.
What I said that they will stay in Tejpur now, they will give representation, they will then after posting with.
Exactly. Instead of interfering with that, Lordship, because he is otherwise not saying.
If we do not interfere, then orders will come, he has not joined,
Yes.
No.
and stay orders are vacated.
Yes.
Stay order, I cannot keep it alive.
But till that period of time, his posting should not be, because this representation is to be filed. So for 2 weeks, the representation will be filed within a stipulated period of 2 weeks. And next 2 weeks, it will be disposed of. So till that period of time, because he is otherwise agreed to go to Kashmir law.
They will work in the said capacity at
Exactly.
Tejpur only.
Yes, but they are still working since 24. They are working.
They are working, let's
Yes.
work here.
No, that is what I'm submitting, Lordship, because if this transfer order is transferred, because he is not saying anything malafide against the order, only he is saying that these two, the spouse is to be transferred to the same place of posting. So the malafide is not there, so there is no scope for interference with regard to that particular order.
Lordship, they can.
No, not only on malafide grounds, there can be other grounds also. So I'm interfering.
Lordship, they can pass a fresh order. They don't have.
They will, who are the person only,
Yes.
give a fresh order.
Yes.
Okay.
Much of
And the other case,
No, Lordship, these two cases, a similar order in the other petition.
in the light of the,
Common
The common order.
oh, it's common order.
Common
It's
order.
common order. Teacher, প্রথমটা লিখে দিবা, this order is passed. What do you say? This order is passed commonly in respect of both the petition.
Since issues are same, Lordship.
As a, this judgment and order is passed in common, or what do you say? I don't remember.
Issues are same, Lordship.
No,
Transfer.
are passed both in respect of petition number so and so and so and so. Return number. No?
Much obliged. Highly obliged.
No, Miss Saikia's matter. There is not much time left. Yes, Miss Saikia. 8:51 হলো। 53, yes, Mrs. Saikia. What happened on the last occasion? I'm told that speaking order was passed or something.
All took time, she's not. The respondent number 5, who's appearing for the principals, he was supposed to place certain instructions. And on the last occasion also, last to last occasion, direction was given by this court that the record has to be placed. So that is required, your lordship, the record and also the instruction. And today it seems.
Hearing has been completed. So how many years this 7
Lordship-
years has gone?
Lordship, I was not
7
present on
years.
the last occasion and the other counsel was present for appearing for the secondary education in lordship. And she had said that the hearing was not complete on that day, your lordship.
Complete. Your lordship wanted to pass the order.
Because
Then
What is that? 90 days? No. What was the issue? I
the
forgot.
issue was, my lord, that he was on medical leave. He undergone 3 bypass surgery
Oh,
during
yes,
that
yes,
period.
yes.
Yes, my lord. So, my lord, one
and lordship.
advisory was passed that was to be explained that he has been absent. Actually, my lord, he has been absent on medical leave. Number 2. Number 3, my lord, that increments has been not been given during that period.
But then today there is problem. She is not there. You, Nanda.
Lordship. She
You,
was,
Nanda is not there today.
today it seems she is not there.
She has taken time. It is her responsibility to come, my lord. So she neither took time nor my lord. And I want to place to judgment, my lord. Earlier, my lord, on the petition itself, I have stated that is in page 17.
Okay, we will pass in the presence of you, Nanda. And there is another order that respond number 5 has to produce the record.
Place the record because the period during which the application was given for leave,
That's so many orders were passed for records. But my lord,
because the leave was not granted because it was given in a plain paper and it was not given in proper format. And we have to sanction it only when it comes to the principal, your lordship. It has to be forwarded
that
to
is
us.
the issue.
Then
That is
only
the
we can
issue.
sanction
Principal did
because
not forward the application.
This is what her contention is.
still, for that the
It
principal
is-
has to be here.
Okay,
The principal.
the learned counsel for respondent number 5 is given the last opportunity to place the instructions and also to place the records. List this matter again on. When do you want?
Any day, that's Tuesday or Thursday will be better.
Readings are complete otherwise, your lord.
List this
Not
matter on
this.
7th of April.
7th
7th of April. You tell Miss Yunanda.
Even I am not aware who.
Huh?
You, Nanda.
Or it is wrongly written here. You, Nanda, my
7th
steno.
April.
You are aware of
Pardon,
you,
my lord,
Nanda?
because hearing is completed, argument also completed. Pardon, my lord, this time is pardon. Otherwise, bench may change.
Lordship.
But then you bring the instructions. If no new Yunanda is there, you bring it and place the records. Who is respondent number 5?
5 is the principal, your lordship. Principal of that
Principal,
school.
present
So
principal.
it's a private counsel.
Private
Private
your
counsel.
lordship. Private counsel.
Her name is not shown in the list. Acha, she is junior to Mr. Biswas, I think. Oh. Huh?
J.
You-
Ghosh.
Michelle.
In the cause list, the respondent number 5
Huh?
name is
Name is shown.
Miss J. Ghosh.
Jay Ghosh is another junior to Mr. Biswas. Mr. Saikia, what you do is instructor, tell your junior to find out Yunanda. She is, I think, junior to Mr. Biswas. And tell her to be present on the next day. Okay.
Your lordship only make it pardon, my lord. Only honor is to first.
Yeah, it's okay.
Because it
Otherwise,
will-
I also don't remember the text
otherwise,
now.
my lord, it will again, I have to, so many times before Mr. Justice Jamir, my lord, more than 15 times, my lord, or 10 times I have argued the matter. But for this reason,
It's
that
okay.
reason, they have to.
It will come from me. Don't worry. Yes.
Okay.
I will,
52, Mr.
the
P.
whole day I have spent this.
That's
from
what
me, my lord.
even I felt bad, but in her absence.
The
it will
etiquette
not
of
be-
the government advocate. They will take time. Wonder it's because they are duty bound to stay, but we are not duty bound to stay up to 4 o'clock. So, don't worry.
May I please through your lordship, we have filed an amendment post title. Kindly Mr. may come up after application.
Heard, Mr.
R.K. Mohanto.
R.K. Mohanto, learned counsel for the petitioner. And you are for?
I am for respondent.
Respondent number 1. and Mr.
DK Bora.
DK Bora for respondent number 1, 2, 3, 4. Service complete.
Actually, my lord, respondent number 2.
Now that he is implemented, you have to take steps. The learned counsel for the petitioner is directed to take steps for service of notice upon respondent number,
3 and 4 months.
not 3 and 4. There is another one, 5. No. You're not clear with the facts. Be clear with the facts and come.
Come after vacation, actually conducting council P board law has left the board.
Don't write anything. List this matter again on when?
After vacation, Lordship.
List this matter again on 21st of April.
Obliged.
21st or 28th. Yes. What matter? Which one?
My lord, 55, my lord.
Hearing.
Yes, my lord. My lord, last order 10/2/2026, my lord. As per this order, my lord, record was called for from the department, my lord.
Yeah,
10/2.
you are-
May I please your lordship? Lordship, earlier, Ardhar was appeared in this matter, my lord. Due to election duty, officers are busy, my lord. They can't provide now. So after election, matter may become, my lord. 3 weeks time may given. 3-4 weeks.
For production of the records.
Records, my lord. The petitioners is not getting their salary, my lord, since 2018. In the meantime, petitioner number 2 has already died, my lord. Their the legal here is, my lord, in record.
Okay, we will see it on the
My
next
lord.
day. As prayed for by the learned counsel appearing on behalf of Mr. Ardhar.
My lord, PW is standing counsel for PW.
You are for PW? Okay, we miss
M. Das.
M. Das, learned counsel for PWT, submits that the conducting counsel, Mr. Ardhar,
Yes.
is indisposed, and he is also not able to unearth the records of the petitioner, unearth the records of the case, and has prayed for some time. Prayer is allowed. List this matter when?
4 weeks, my lord.
List this matter in the first week of May.
Date may be before. It's urgent matter, my lord. They are not getting any salary, my lord.
List this
They're
matter
very
on
poor person, my lord.
7th of May, 2026.
Highly obliged, my lord.
CBO.
Please, your lordship. Lordship, this matter is fixed for hearing, your lordship.
Please, lordship, this hearing is reading by J.K. Goswami, lordship. He is not present today. Kindly fix the matter after verification.
Yes, your lordship. A date may be fixed, your lordship.
Miss S. Borua, learned counsel
All respondents.
for the respondents,
Right.
submits that Mr. J.K. Goswami, learned additional senior government advocate, is indisposed, who is dealing with the matter, is indisposed, and has prayed for some time. Prayer is allowed. List this matter when?
Your lordship, 23rd of April, your lordship, that will be a hearing date.
23rd of April, 2026.
Much obliged, your lordship.
Mr. Arti Sharma was there. 58. List this matter again on? Again on 23rd of April. Okay. Okay.